Yes, please, Your Lordship. My lord, this civil division petition is pending for a long time, my lord, and other side also appeared. So otherwise, this matter can be disposed of at the admission stage. May I pay for listing in the next Friday,
Pray before registry.
my lord?
Pray before registry.
Also, I paid for a listing of a new CRP IO lordship on 15 lots.
What is the urgency?
Urgency is the appellate trial court has rejected the injunction application. Petitioner the defendant. However, appellate court granted injunction to debar from holding the AGM of the society lot.
Okay, 15.
May please your lordship, with regard to item number 12, my lord, without the consent of the opposite party, my lord. The matter may come after 2 weeks, my lord, to take some personal difficulty.
Why?
Huh?
Why?
Some difficulties, my lord. Item number 12,
What is your name?
B.K. Borua, my lord.
PP
B.K. Borua, item number 12,
DK Burra for petitioner.
lordship. B.K.
Heard
Borua,
Mr. DK Burra,
B.K. my
learned
lord.
PK Burra, learned counsel for the petitioner who prays for an, you have informed the other side,
Lordship.
who prays for an adjournment on the ground of personal difficulty of the conducting counsel. He submits that he has informed the counsel for the respondents regarding his prayer for adjournment, who have no objections to the said prayer. Hence, the prayer is allowed.
I love that.
May I please, Your Lordship? Your Lordship, I pray for listing of a miscellaneous first appeal for admission, Your Lordship. On the last occasion, Your Lordship, there was none appearance of the appellant, Your Lordship, because of the non-reflection of the counsel for the appellants, Your Lordship. So I pray that the matter may be listed for admission any date, Your Lordship.
Next Monday.
Much obliged, Your Lordship.
May I please, Lordship? I'd like to mention one CRP matter. Because of the pendency before Honorable High Court, the matter has been kept in same condition like necessary orders since last September, that is 24th September year.
What was the last order?
Last order was in the month of June year. It was
What-
listed,
What was the order?
it was listed for admission maybe, Your Honor, because we have already submitted our evidence on affidavit here
Next Tuesday.
next Tuesday. It may be on 25th, 15th or 16th of this week, maybe
16th is a holiday.
15th or 16th, maybe or 17th also for admission
Next Tuesday.
next Tuesday. Also.
Make this the Lordship. I beg to mention item number 28 with the consent of the other side.
28. Yes, what is your prayer?
Kindly it be listed on the 1st of November, first week of November.
Why?
Some difficulties is there.
You have to mention the reasons also when you are praying for adjournment. What is your name?
It's not.
Heard Mr. H. Nath, learned counsel for the respondent. Also heard Mr. Arbor Pujari, learned standing counsel,
Council of Age 61.
learned counsel appearing for the petitioner. Learned counsel for the respondent prays for an adjournment on the ground of personal difficulties. The counsel for petitioner does not oppose the prayer, hence the prayer is allowed. Let this matter be listed on any fixed date.
Subject to matters continued. Can be in the first week of November.
In the first week of November on a date to be fixed by registry.
May I please, Lordship? Next Tuesday may be holiday on account of Dipanita festival probably.
Then Wednesday.
Next Wednesday, maybe on 22nd.
May it please your Lordship, I beg to mention item number 25, Lordship. I'm seeking for some time to file our substitution petition, Lordship.
File what?
Substitution petition.
What's your name?
You Bharadwaj, your Lordship.
Item number 25.
Yes, your Lordship.
You are appearing for whom?
Mr. T. Deori, on behalf of Mr. T. Deori.
Heard Mr. U. Bharadwaj, learned counsel for the petitioner, who prays for some time for filing a substitution petition in this case. The prayer is allowed.
Much obliged.
Let this matter be listed on a date to be fixed by registry.
May I please, Your Lordship. Your Lordship, I beg to mention for listing of two RFS lawsuit. The matter has been pending since long, and on the last day of occasion, the matter has been not listed. Listed, but has not been raised lawsuit. And I said it is regarding realization of money lawsuit. There is an urgency lawsuit, can it be listed on?
What
just
urgency?
Realization money at the matter, we have not, though decreed the suit, but we have not realized the money till date. And the matter has been pending since long. Lordship, we are praying for Thursday lordship.
Pray before registry.
Lordship, a date may.
Pray before registry.
May I please, Your
But
Lordship.
my lord, I beg to mention for listing of RSA, my lord, on 1510, my lord. Or because execution case is going on, my lord, on 1610, police cost is, payment of police cost is
And-
there. Already filed. RSA is,
Motion stage.
already filed your lordship.
Okay.
May please, your lordship. Lordship, with the consent of the other side, my lord, I beg to mention item number 38, my lord,
30.
38. Already consent, my lord. My senior is now out of education, my lord. So matter may be fixed after 2 weeks, my lord.
What is your name?
Arrive here.
Heard Mr. R.I.
Bhuya.
Bhuya, learned counsel for the petitioner,
Yes, my lord.
learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. You have informed the other side.
Yes, my lord.
He submits that he has informed the learned counsel for the respondent side, who does not have any objection to his prayer. Hence, the prayer is allowed. Let this matter be listed on a date to be fixed by registry. Yes.
Yeah, Your Lordship. Lordship, I beg to mention item number 27. Your Lordship, as my senior counsel is out of station.
37.
27. Lordship.
Yes. What is your name?
SK Lahan.
You have informed the other side.
Yes, Your Lordship.
Heard Mr. S.K. Lahan, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. The learned counsel also submits that he has informed the learned counsel for the respondent regarding his prayer for adjournment, who has no objection to the said prayer. Hence, the prayer is allowed.
May I pray for listing of an appeal against the refusal of injunction tomorrow? So we filed it on 25/9. We also attempted to.
25/9.
25/9.
Okay. Okay, tomorrow.
Grateful.
If it's your lordship, also I beg to mention item number 39. Lordship, let the matter taken up on next week.
Why?
We have served a notice, but the opposite party has not appeared.
Heard. Miss, what is your name?
A Boro.
Heard Miss A. Boro, learned counsel for the petitioner, who prays for listing this matter in the next week, as no one has appeared for respondent side till date. The prayer is allowed. List the matter accordingly.
My lord.
Item number 1.
My pleasure. Charge sheeted matter, Your Lordship, earlier disposed of Your Lordship. And not to negate Your Lordship, but earlier, before filing charge sheet, it was filed.
When charge sheet was filed,
Charge sheet is filed on your 30/5/2025.
earlier disposal was after filing on the
After file, 37. Due to filing of charge sheet, it was disposed of and directed the petitioner to approach the learned trial.
You
court.
approach the trial court.
Yes.
Where is the rejection order?
Rejection page 21. Page 21, annex 3. Petitioner
Yes,
present.
notice will have to go. Heard Mr. S. Islam, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Let the scanned copy of the trial court records be called for. Let also notice be issued to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice within 3 days from the date of this order, returnable on 7th of November.
Already in this 27. Because it's wrong.
Returnable on 27th of October.
Published.
Lordship, there are two more criminal matters. There are two more criminal matters listed in the orders column.
We will take it up now.
Lordship, yes. if possible. If they are available. 41 and
Item number?
41 and 42. Forty-one, probably the council is not present, Lordship.
What? Call 42.
42.
We'll take it up. Item yes,
Your Lordship. Lordship, my senior is unavailable in the court. Could you please pass over the matter for the council?
Lordship, then may I pray, Lordship, a specific hour may be fixed, Lordship.
at 3:30. You suggest
Two, Lordship.
2, at 2. At 2, we'll take up 41 and 5.
Also, item 2.
Why this case has been listed in motion column?
Wrongly listed, Lordship. Maybe listed in admission column.
It is wrongly listed in motion column.
Let this matter come up on Friday, my lord.
Otherwise, matter is ready for
Yes, yes, lord. Case is also very simple. If your lordship kindly peruse annexure 6. They are here
no,
before. your-
let us not take it up today. Or can it be disposed of today?
Yes, lordship. It can be disposed of today. Can be
itself.
disposed of, my lord, because I have heard that one respondent has died. But who has died, nobody could give any detail.
No, let us fix it in admission column.
Then Friday, my lord. Then Friday, matter is of 2018.
Yes. Heard Mr. R. Goswami, learned counsel for the petitioner. Also heard Mr. R. Ali, learned counsel appearing for all respondents except
Respondent, I am going to file Wakalatnama on behalf of respondent number 5 also.
all respondents. It appears that this matter has been wrongly listed in motion column, whereas the matter is ready for admission hearing. Let this matter be listed in admission column
Friday.
on 15th, on 17th,
20.
on 17th of October.
Hello. My lord, in the meantime, the order dated 10/3/2025 may kindly be extended till Friday.
Is there any stay?
Yes, yes, lord. Execution proceeding is stayed since 2018.
The interim order shall
Passed earlier.
passed earlier shall continue till next day.
Obviously.
In this case, my lord, we have approached this honorable court against the order passed by the learned tribunal. That is at page 186, my lord. What had happened, my lord, this case was filed during the COVID stage before the DRT. The original application was filed. Notice was not served upon us. That is evident from the order which was passed. And at page 111.
But paper publication was there.
Paper publication was done, but that at that time, it was during the COVID stage, my lord. Into February
January, February 2021. We came to know only when the recovery officer had issued a certificate asking us to appear. Then we had filed the application for setting aside of the ex parte order which was passed by the learned tribunal. The learned tribunal, while passing the impugn order at 12/9/2025,
Where is the impugn order?
that is at page, my lord, 186, my lord. The operative part is at page 190 onwards. This, the finding of the learned tribunal.
This order has been passed in a delay
In the, in
condon.
the, in the delay condonation
delay-
application.
Delay has not been condoned
Yes, my.
on
So
the,
on the ground, my lord, if my lord may kindly peruse page 192, that is a wrong finding. Last line, my lord, page 192. The learned tribunal has held that last line, each and every day of delay is to be satisfactorily explained by the petitioner. But in the present case, the applicants have failed to show any sufficient cause for condoning the delay in their application filed for condonation of delay and the application for setting aside of the ex parte judgment and order. It was not allowed. But my lord may kindly peruse a judgment of this of the apex court.
no, how you have explained the delay?
My
What-
explanation, my lord, if my lord may kindly peruse the application which I had filed under section 5. That is annexure.
When you came to know about the,
I came to know, my lord, on 28/8/2024, when I received the notice from the recovery officer.
and from this,
And I had filed this application on 28th November.
Lordship, I do not have the copy of the applications.
I will serve him a copy, my lord, because
you are
there is no,
appearing,
Yes, I am appearing for Indian Bank.
I'll serve him a copy. I'll let it come up on Friday, my lord.
you serve him a copy.
Yeah, I'll let it come up on Friday.
Or we issue notice.
Notice,
Your main ground is that as it was during COVID-19,
yes, my lord.
paper publication is not effective.
Yes, well, because no one was, newspaper circulation was at the minimum.
Your Lordship, as far as my instructions is concerned, that in this case, the judgment has already been passed. And after passing of the judgment, they can take this plea before the appellate tribunal also. They
Under
can file an appeal
two-
before this court.
227, the court has the power.
It is
my lord.
not that the
I-
law
I-
has left them remediless.
I have the judgment, my lord. 227, the court has the power.
Judgment has already passed.
Ex parte, I have filed an application for setting aside of the ex parte because along with it, the section 5 was filed. The court has rejected my section 5.
And thereafter,
Thereafter, now I have filed this application now.
Your
Matter is
Lordship,
pending before the
that
recovery.
has
of-
been happened only after passing of the judgment.
no, their plea is that they came to know about the order only at this execution stage.
Yes, my lord.
That-
Execution stage, yes.
Yes,
So, but in the Recovery of Debts and Bankruptcy Act, there is no provision that they can file in review, but it is after passing of the judgment. And review is only for the 1 month, your lordship. So where is the law decides to that they can go for the setting aside of the ex parte judgment?
Let it come up on Friday. I will serve him a copy.
okay. Heard Mr. What is your name?
Yes, Khan.
Heard Mr. S. Count,
Okay.
learned counsel for the petitioner. Also heard Mr.
M. Sharma, your lordship.
M. Sharma,
I
appearing.
do not know that how for whom that I am just.
And he's for Indian Bank.
No, Aru Hassan Gina,
no, only-
only sole. Yes, your lordship. Only sole
appear-
respondent.
appearing for the sole respondent. This application under Article 227 of the Constitution of India has been filed by the petitioner impugning the order dated 12/9/2025 passed by learned presiding officer Debs Recovery Tribunal Guwahati in IA number 780/2024 in ERDT diary number 871/2024 within bracket MA arising out of OA number 88/2020, whereby the prayer for condoning the delay. How much delay was there?
968 days. 968 days.
Delay of 968 days in preparing the prayer for setting aside the ex parte order was rejected. Stop. Learned counsel for the sole respondent has submitted that he has not received the copies of the copy of the instant petition. So the petitioner is directed to furnish copy of the petition along with the annexures during the course of the day. Let this matter be again listed on Friday, 17th October in admission column,
No, in motion, my lord.
in motion column.
And the prayer for interim, if any, will be considered on that day, my lord. Then the entire matter can be taken up.
No, we'll see on that day.
Yes, my lord.
It is in the motion.
Motion
Definitely that the interim will be considered.
I think for.
No problem.
May please, your lordship. My lord, this petition has been filed challenging the impugned order at page 94. Here the petitioner, they have filed suit for declaration and correction of records and injunction. Because the defendants, they are trying to dispossess this petitioner. And when the defendant appeared and filed WS disclosing that the land, Patta land has been converted to a khas land. And when they got the information through the WS, they
You-
filed an amendment petition.
You are petitioner or defendant? You are plaintiff or defendant? You are plaintiff.
Plain. So after WS, we came to know that the land record has been converted by the circle officer. Then they file a petition for implement of the circle officer. There has been objection to by the other side, and the learned court below has hold that the circle officer ought to have been implemented at the time of filing of the suit. And ultimately rejected,
Where is the impugned order?
my lord, at page 54.
50?
54. Annexure 9. My lord, in paragraph 3 itself discloses that at the time of filing WS, defendant disclosed the suit land is a common caste land. And prior to the year 2011, annual patta had been issued to the defendants.
We'll issue notice. Heard Mr. A.K. Sigdar, A.R. Sigdar, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner, namely Fazor Ali, impugning the order dated 18/6/2025, passed in Ms. J case number 128/2024, arising out of title suit number 85/2022, whereby learned civil judge senior division Goalpara had rejected the amendment of rejected the prayer for amendment of the plan and impleading the circle officer. Circle officer where, which,
My lord, with respondent number, as a respondent number 4, 4 and 5, I have stated at page 47, my lord, the proposed amendment.
circle officer has,
Respondent number 4 and state of Assam represented by the deputy commissioner as respondent number 5.
as well as state of Assam as defendant in the suit, issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by registered post with AD, as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
My lord. Further proceeding may be,
It is your suit.
my lord. My lord, the trial court has passed order to submit evidence, my lord. Evidence is not even submitted, my lord. The proceeding may be kept suspension. My suit, but I am in inconvenient position, my lord.
Stop. Considering the plea taken by the petitioner in this petition, as well as facts and circumstances of this case, further proceedings of the title suit number 85/2022 pending in the Court of Learned Civil Justice Senior Division, Goalpara, is stayed till next returnable date.
Deeply obliged.
Yes,
May it please the Lordship, here in this case, the respondents herein is the plaintiff file a suit before the learned court of Munship number 1 Dhubri for right title and interest. Thereafter, the petitioner filed their written statement and subsequently both the parties has reduced their evidences and cross-examination have already been done, madam. Thereafter, the case was fixed for final argument. In the meantime, the respondent filed a petition under Order 6, Rule 17 for amendment of the petition. And that amendment petition was rejected by the learned court below. Then they came to before this honorable court. This honorable court also dismissed the petition, which is at page 42, my lord. And
what are you impugning?
my lord, impugn page 55. Finally, my lord, at the final stage, they again filed a petition by saying that the learned court below has the no territorial jurisdiction to try the case. But in fact, they have filed the title suit before this honorable, before this learned court below.
Now,
And-
where is the case?
My lord,
Where is the suit pending now?
pending now in before the Munship number 1 rule,
It has not yet been transferred.
not yet been transferred.
Yes. State has anything to
6 and 7, Lordship. And well, that
But the
page number 56, Lordship, that's
50?
6.
Where is the error? Where is the error in the,
Malada, here in this case, if the territorial jurisdiction is concerned, Malad, the respondent number, office of the respondent was 6 and 7 is at 2. And the title suit filed by the petitioner itself.
no, a new district was carved out
But a new district has been carved out in the year 2016.
when the suit was
And
filed.
suit was filed in 2017. Knowing fully the fact that the district has been bifurcated.
The- What stage this suit is pending?
Well,
now?
This is at the final stage, final argument. Prior to that, this suit was dismissed for default. Four times they did not appear. The suit was dismissed. Again, they filed a petition for restoration and subsequently restored and fixed for final argument. At this stage, they filed this petition by saying that there is no territorial jurisdiction of the Supreme Court.
No, you participate in the suit in the court which has jurisdiction in Hatsingmeri, you go and argue the case will be disposed of. If we interfere at this stage, it will be delayed by how many years, you may not say.
So, my lord, at this stage, my lord, my humble submission before your lordship, since the office of the respondent number 6 and 7 is at Dhubri. So as per section 16 and 20 of the CPC, my lord, the Dhubri has also the
As
jurisdiction.
far as the new bifurcation of new district lordship, there is the office of the 5, 6 and 7 is also there lordship.
After bifurcation.
So it is the jurisdiction of lordship, district commissioner South Salmara.
In that case, my lord, since the plaintiff themselves plead before the court at the last stage. So on that ground, this learned court below may ought to have been dismissed their petition with the liberty to file afresh. Because this is not the question raised by the petitioner respondent therein.
No, but now what is your challenge? Where the court erred?
My lord,
Your
what-
challenge is that respondent number 5 and 6 office is in Dhubri,
in Dhubri.
but now it is also there in Hatsingmeri, South Salmara.
Maybe subsequently, but still I have the information that still office is there. The settlement office is still in Dhubri, but the circle officer is there. So let it take instruction on that issue, my lord.
As per my understanding,
And-
district commissioner office is there lordship, but
My,
immediately after lordship, bifurcation of this district lordship. So there is a district commissioner,
and
settlement-
district has bifurcated in the year 2016.
yes, sir.
Under what provision the jurisdiction is there? Which provision? 16 to 20,
Yes,
which provision?
my lord, regarding the,
Where the defendant
Yes.
reside,
yes,
which is that provision?
there is section 20A.
We issue notice without interfering without giving any stay.
With if the order has been passed
No.
subsequently, then
If heard Mr. R. Islam, learned counsel.
that order may be subject to outcome, my lord, if any order passed during the pendency of this case.
Okay. Heard Mr. R. Islam, learned counsel for the petitioner. Also heard Ms. D. Burman, learned senior, additional senior government advocate, appearing for respondent number 5, 6 and 7. This application under Article 220, under section 115 of the Code of Civil Procedure 1908 has been filed by the petitioners impugning the order dated 2/8/2025 passed in TS title suit number 170/2017 by the Court of Learned Civil Judge Junior Division number 2 Dhubri, whereby it had transferred the suit to the competent court in the district of South Salmara, Mankachar. On the
South Salmara Mankasar, not Poma, my lord.
South Salmara, Mankachar, on the ground of territorial jurisdiction. The petitioner is impugning the order mainly on the ground that since the office of the defendant number 6 and 7 is there in the district of Dhubri, the Court of Learned,
Conchip number 1.
Learned
Even that,
Civil Judge Venue Division number 2, Dhubri, does have the jurisdiction. So issue notice to the respondents. Since learned additional senior government advocate has appeared for respondent number 5 to 7, no formal notice need to be issued to the said respondents. However, in respect of the other respondents, the petitioner shall take steps for issuance of notice within 7 days from the date of this order, returnable on 14th of, when is the next date?
But next date not fixed.
Already, Lordship, the
Next
impugn
date not
order,
fixed.
order is 2/8/2025, Lordship. And page number 56, Lordship, the record we put up before the Honorable District Judge Dhubri for passing necessary order, Lordship. Already order has been passed.
Let us see. Let the, on 14th of November.
In the meantime, any order passed, that will be subject to acknowledgement. Petition.
No. We'll see the records.
Public.
Item 6.
May it please you, Lordship. My lord, in this matter, my lord, I am a Guwahati-based real estate company, my lord. And my lord, I provide services, real estate services, such as if any person, if any of the person is coming to me and rendering my services and want to acquire a real estate property or lease a property, I provide them the data and provide them the site visit and consultancy services in regard to availability of the various property in Guwahati, my lord. And if I have an investor, then I provide them property, or if I have a property, I find an investor and connect it to my customers. Now, my lord, in this matter, there is a multinational company named CBRE. So CBRE, my lord, has approached me, having a investor, and they sought various properties, warehouses based out of Guwahati, my lord. And my lord, I have provided them with details through email. Everything is on email, my lord. I provided them various details of the warehouses. And my lord, after providing those services, details of the warehouses, the CBRE, there is an employee of the CBRE and the investor, both of them, I provide them a site visit to the property also, to both of them, my lord. And after that, once I provided them the site visit, my lord, this CBRE, the multinational company, my lord, has gone behind my back and have directly approached this landlord, the property, and they have directly made a deal and cutting me out of it. And the entire consultancy services and the information and everything was conducted inside the site visit, the providing the details of the property. I have only provided, my lord, and it's not the first time I am rendering such services to CBRE.
You are a broker.
Brokerage, real estate brokerage company, my lord, based out of Guwahati, my lord. And now, my lord, it's the second time I'm providing these services to CBRE, my lord. What CBRE has done, they have gone behind my back and they have get the transaction done, my lord. Subsequently, my lord, I have preferred a money suit in a form of a commercial suit, my lord, before the lower court, my lord, civil judge senior division, my lord. And when the matter was filed, my lord, the date was fixed on 1st of November, my lord. And the matter was filed in September, my lord, way long before that, my lord. So, and my lord, I had an interim prayer that the owner of the property, that is Jericho Chemicals, and the Berger Paints, the investor, may be directed to not to make any payment of the brokerage amount to the MNC, my lord, until the disposal of the money suit and the commercial dispute, my lord. However, my lord, the learned senior division has passed an order stating that we do not find any
No, why they will pay brokerage amount to anyone else if they have directly approached the
My lord,
owner?
I have provided the services to the property owner.
For that, you have already filed a money suit.
Yes, my lord.
If ultimately you are found entitled, you will get it.
Yes, my lord.
That is there, my lord. But at the same time, my lord, if an interim relief may not be granted to protect me from the payment being made, because that payment, my lord, 50% of the amount is supposed to be being paid to me, my lord, in the entire transaction. I have facilitated, I have provided them the information, I have provided them all the relevant details of the various properties. I have conducted the site visit, my lord. And now, my lord, the payment, they have made the deal directly, my lord, without informing me, my lord. I just came to know and immediately I filed a money suit, my lord. I have also issued them various emails and various filed a complaint in their complaint portal, my lord. However, no resolution was.
What is the stage of the transaction between sale transaction?
My lord, a lease deed. It is lease transaction, my lord. The
Lease-
lease deed has been executed between the
Money
parties.
has been paid on.
My lord, he has not been paid. That's why, my lord, I am here that the interim relief may be granted until the disposal, no payment being made, so that it may protect me, my lord. And it will
No,
also
but-
help in mediation, my lord.
But you will not suffer any irreparable loss, which cannot be compensated in terms of money.
My lord, if
It is a
one-
question of money only. So there is no urgency.
That-
And today is 13th,
yes, my lord.
date is fixed on
1st of November.
1st
my
of
lord.
November. Only 17 days are remaining. What's loss you will suffer?
Yes, my lord.
Suppose money is transaction of money between owner and the purchaser is taken place.
Yes,
Later on, you are found in the suit that you are entitled. Then you will be entitled.
yes, that is there, my lord.
So
I'll-
there is no urgency.
My
And
lord,
what is your grievance? Your grievance is only with regard to the fixing of a long date.
my lord, it's fixed on 1st of November, my lord. And the learned court have stated that the early hearing cannot be granted since the mediation has not been invoked, my lord. Once the mediation is invoked, my lord, they will be in a liberty to make the payments, my lord, and my payments are being withheld, my lord. There is a prima facie case that there is a breach of contract committed. They have.
But there is no irreparable loss. Which cannot be compensated in terms of money. You satisfy me on that point.
Right.
Otherwise, this is a case of dismissal.
My lord, there is a urgent relief sought since once the payment will be made, my lord, then the entire proceeding, my lord, my petition money suit will become infructuous. my lord.
How it will become infructuous? If you are found entitled, you will get it. It will be recovered from anybody who is unduly getting the money. It
Yes,
will not become infructuous.
But at the same time, my lord, if interim relief is not granted, the mediation, my lord, at the stage of mediation.
No, you fail to satisfy this court that you have a case for interim relief in this case.
Yes. The prima facie
I am
breach of
going
contract,
to
my lord.
dismiss your,
My lord, it's a prima facie case of breach of contract, my lord, and I am entitled.
you are not against, you have preferred this revision. That too invoking 227. You have invoked 115. That is not maintainable. Due to the proviso to 115.
Yes, my lord. My lord,
You
Yeah.
have two options.
yes,
Should I withdraw it? Should I dismiss it? Or you withdraw it?
my lord, there's just one submission, my lord.
Or you convince me? You are failing to convince me. Is this which order you are impugning? 11-9.
My lord, if your lordship may just look upon section 12A of the Commercial Code Act, my lord, in this regard to mediation, my lord, that if urgent relief is required, my lord, the court may consider granting urgent relief, my lord. Because
No, but your case is how it can be in the nature of urgent relief when it concerns only payment of money,
my lord,
which
the payment has not been made till date. The prejudice has not been happened to me till date. If the payment will be made, the
you will
prejudice.
not suffer any irreparable loss.
Yes, my lord, but I'll definitely face the prejudice, my lord. Rest I leave
But
upon your lordship. if your
But in
lordship
a
will
civil
consider.
case, unless you satisfy the three principles, you are
Yes.
not entitled to get an interim relief. Heard. Mr. D. Rathi. What question of maintainability is there?
My lord, I have not invoked the mediation.
So question of maintainability is also there.
My lord, in regard to
12A.
maintainability, my lord, section 12A, it is stating that in case of an interim relief, the parties can straight away file the suit before the court if there is urgency, my lord. That's why before invoking the mediation, we prefer the money suit.
Heard. Mr. D. Rathi, learned counsel for the petitioner. This revision petition under section 115 and how it is, this revision is maintainable. This maintainability of this revision petition.
My lord.
This you have filed under 115.
Yes.
You read the proviso. Read first proviso to 115. Proviso to 115. You have CPC with you. Take this
My
one,
lord.
read it, and then tell me, is it maintainable? You are impugning order dated 11/9/2025.
Yes, ma'am.
You test that impugn order in light of the proviso. Read proviso first.
The High Court may call for the record of any case which has been decided by any court subordinate to such High Court in which no appeal lies thereto. If such subordinate court appears to have exercised a jurisdiction not vested in it by law, or to have failed to exercise the jurisdiction so vested, or to have acted in exercise of the jurisdiction illegal or with material irregularities, the High Court may make such order in case as it thinks fit. My lord, subsection B, my lord, if within to have failed to exercise the
No, no,
jurisdiction.
you read the proviso. I am asking you to read the proviso.
Yes, ma'am. High Court, provided that the High Court shall not under this section vary or reverse any order made or any order deciding an issue in the course of a suit or proceeding or other proceeding, except where the order, if it had been made in favor of the party applying for revision, would have finally disposed of the suit or other proceedings.
Whether this clause is satisfied, it is only question of a date. It fails. Whether your case comes within is, are you able to overcome the proviso?
My lord, this
Had the
provision,
date, instead of, the date is fixed on
1st of November, my lord.
1st of November. If date would have been fixed by the court on some other date, would it finally disposed of the case?
Interim protection, add interim protection.
No, you read that. It fails to,
Provided that the High Court shall not under this section vary or reverse and any order made or any order deciding an
Amita
issue
Dekho.
in the course of a suit.
heard Mr. D. Rathi, learned counsel for the petitioner. This revision petition, CPC company, this revision petition under section 115 of the Code of Civil Procedure 1908 has been filed by the petitioner impugning the order dated 11/9/2025 passed by the Court of London, Civil Justice Senior Division, Kamrup, whereby it rejected the prayer for an early hearing of the case on the ground that question of maintainability issues exist. Learned counsel for the petitioner has submitted that the petitioner has preferred a commercial suit,
Money suit.
has preferred a money suit claiming brokerage for the services provided to the respondents. It appears that the next date of the suit has been fixed by the trial court on 1st of November, which is only 17 days from today. The learned counsel for the petitioner submits that as a prayer for an interim relief was sought for by the petitioner in the said case, that is within bracket money suit number 356/2025. And early date of hearing was prayed for. Learned counsel for the petitioner has also submitted that the petitioner had sought the interim relief of not disbursing 50%,
50%.
not disbursing the brokerage amount which is due to the petitioner to any other party. Stop. And therefore an urgent hearing was prayed for. Stop. Apart from the fact that I have considered the submissions made by learned counsel for the petitioner and gone through the records available before the court. Stop. Apart from the fact that the interim relief which is sought for by the petitioner before the trial court appears prima facie not involving any irreparable loss which cannot be compensated in terms of money. There is an apparent embargo in this, preferring this revision petition in view of the proviso to section 115 of the CPC, which provides that if the order which has been impugned had been made in favor of the petitioner, would have finally disposed of the suit or proceeding. Only in such case, this revision petition would have been maintainable. Stop. Which is not the case in the instant case. Thus, this court is constrained to hold that this revision petition is barred by the proviso in section 115 of the CPC, Code of Civil Procedure 1908, and accordingly dismissed.
No problem.
Item 7. Meet with you. My lord, petitioners are aggrieved by the order of rejection of their petition which they filed in an appeal filed by them. The petition was filed under order 1 rule 10, order 6 rule 17, and order 41 rule 33 of the Code of Civil Procedure
No.
before the
no,
learned
no.
appellate court.
No. You are aggrieved with what?
I'm aggrieved by the order of rejection
Rejection.
of my petition, which was filed under order rule 10, order 6 rule 17,
Order, under order?
under order rule 10. That is for
What order
implement-
rule 10?
Order 1 rule 10 for
Order 1
implement-
rule 10.
Order 1 rule 10 for implement of parties.
Okay,
Order 6 rule 17 for amendment of my pleadings in the memo of appeal.
okay.
And order 41 rule 33, which is a power my lord, invoked by the learned appellate court in case of subsequent developments during the course of the pendency of the appeal. So these were the facts. There were facts which occurred after the filing of the appeal and during the pendency of the appeal. May I just,
Who are you?
I am, my lord, actually defendant in title suit number 37 of 1991.
That is a different title suit.
Yes, that's a different. no,
Against
that is-
which?
That is not the, that is actually the title suit against which I have preferred title appeal number 30 of 2004, assailing the eviction decree against me,
Title suit number 37 now.
1991, in which the judgment and decree was passed on 31/5/2004.
You have preferred a title appeal.
Yes, a title appeal number 30 of 2004. Against the eviction decree. And that title appeal is pending. Now, during the pendency of the title appeal, my lord, there were certain developments that took place vis-a-vis the suit length of that particular title suit from which I am sought to be evicted. We are sought to be evicted. The suit length that is a matter of concern of that title suit number 37 of 1991. And against which, and against the eviction decree of which we have preferred appeal and which is pending. Down the line, during the pendency of that appeal, one different person who is not connected with title suit number 37 of 1991, he preferred
In 37 of 1991, you were the
defendant,
defendant.
being the
Suit-
tenant
Suit was decreed against you.
and eviction.
You preferred an appeal.
yes.
Appeal is still pending.
Well.
This is the fact.
This is the fact. And
And
subsequently, during the pendency of the appeal, what happened? The suit length, which is the matter of concern and in which we are concerned with 605 square feet areas of the entire land. from
is
which
land
we
or
are-
room?
Room, from which we are sought to be evicted. Now, down the line, my lord, what happened? One person who was stranger to this title suit number 37 of 1991, he obtained an ex parte decree on 21/3/2013.
He filed a different suit.
He filed a different suit. Absolutely, but in that suit, he incorporated the description of a portion of the suit line and the suit premises falling on that particular dag and patta, which is the matter of concern in title suit number 37 of
No.
1991, and he obtained a,
What was the subsequent title suit?
this is a title suit number 128 of 2012. And an ex parte decree was obtained on 21/3/2013.
Thereafter,
Now, thereafter,
decree was obtained against, you are not the defendant
no,
in that.
we were not added as the defendants in that suit. What we date after coming to know about the procedure of execution that was thereafter initiated in regard to this particular title suit. Your lordship kindly sees there's an order
No,
of
you
the-
first tell me the facts.
Yes. Then-
Execution proceeding
yes,
was
in
initiated
this
in
this
the
particular
subsequent
suit,
suit.
yes, execution proceeding was initiated, and only then we came to know that this person who was this plaintiff in the subsequent suit, he has got an order from the learned executing court of being handed over with symbolic possession in regard to that particular suit land and the portion which we are in possession of, and in regard to which there is a separate litigation that is going on. The present, the appeal that is going on.
What you did,
We thereafter, initially we filed a suit in which we prayed for a declaration that we are not bound by the ex parte decree in the subsequent suit. But later on, we withdrew the suit, and presently in that execution proceeding, we have filed a petition under Order 21, Rule 96, which is still pending. In the subsequent suit, my lord, we
the-
are now litigating in the form of a third party under the provisions of Order 1, Rule 96. We had initially preferred a suit for a declaration that we are not bound by the decree of that subsequent suit, but then thereafter we withdrew it, and then we filed.
what is the suit number of the,
This suit is suit number 128 of 2012 in which.
not 128, which you withdrew?
Oh, which I preferred, that suit number is suit number 85 of 2014, where we challenged the bindingness of the ex parte decree in that subsequent suit number 128 of 2012.
Thereafter, you filed a
will-
petition in the execution proceeding,
Yes, my lord. We
and that is pending.
that is pending. That is pending in title execution case number 16 of 2013, emanating from title suit number 128 of
Then what
2012.
happened?
Now, this subsequent, the plaintiff of that subsequent suit, that alien to the previous suit of 37 or 19, the subsequent,
Title suit 128.
yes, the plaintiff of that suit, he again filed a title suit bearing number 181 of 2018, renumbered as title suit 36 of 2021, in which he sought for a decree for his title over his purchase plot of land, which was decreed in his suit, the earlier suit. Now, this suit is also pending, and in this suit, we have been arraigned as parties. Because of the fact that in his earlier suit, in his first round of litigation, we have entered by way of Order 21, Rule 96. Now, he has filed his subsequent suits, namely, now presently numbered as title suit 36 of 2021, in which we have been arraigned as parties, and presently that suit is also pending adjudication. Now, my lord, insofar as our title appeal is concerned, which we had filed against the decree of eviction, which was passed earlier. Now, because of all these developments which have taken place, we filed that title appeal. I have given the list of dates. We filed that title appeal on 9/7/2004. That is title appeal number 30 of 2004. And all this development started taking place from 2013 onwards. The subsequent suit, the decree, ex parte decree passed in the subsequent suit. Then thereafter, we filing the suit, withdrawing, then filing petition under Order 21, Rule 96. Then this stranger filing another suit under a suit that is the subsequent 136 of it. Now, all these facts, these developments took place after the filing of our appeal, and these facts could not be raised at the time of preferring the appeal. Now, therefore, what we did, we filed a petition under Order 1, Rule 10
Where have you filed that?
in the appellate, before the learned appellate court, in which our title appeal is pending against the eviction decree.
In title appeal 30.
30 years, 30
30.
of 2004. Now, here we have filed this petition
Which petition?
under Order 1, Rule 10, Order 6, Rule 17, and Order 41, Rule 33 of the Code of Civil Procedure. And the necessities which we have cited in our petition are Order 1, Rule 10, because of the fact that the stranger who filed the subsequent suit
and is now claiming his ownership over that portion of land over which we are having a litigation for against the decree of eviction. Now, he is a necessary party. So taking that plea, we have sought invoking the provision under Order 1 Rule 10 CPC. That is one. Then we have sought for amendment of our pleadings in the memo of appeal under the provisions of Order 6 Rule 70. And we have also prayed for invoking the power of the learned appellate court under Order 41 Rule 33 under circumstances, as is the case in the instant litigation. Now, this petition was objected to by the respondents of the title appeal, and eventually the impugn order has been passed, which starts from page 93. It's a very longish order, my lord. It starts from page 97, in fact. Operative part, my lord, is, your lordship will kindly find from page.
Whom you want to implead?
I want to implead the plaintiff of that subsequent suit, that is suit number 128 of 2012, and the person against whom he had litigated, who also is not a party in the earlier eviction suit that was filed against me. And I want to make an amendment by bringing in the subsequent developments which took place after the preferring of my title appeal, and which are necessary for adjudication, because your lordship will kindly consider now both the principal respondents in the title appeal that we have preferred, who were the plaintiffs in my eviction suit, and this person who is now the subsequent decree holder, they are both claiming ownership of the premise in regard to which I have my interest as a tenant, to the extent that I am assailing the eviction decree against persons against whom this person has now litigated, and now the title between these two parties are yet to be ascertained. The litigations which are pending amongst those parties, and now my status of being a tenant, my lord, it has become hazy because of the fact that I now don't know that whether the plaintiffs of title suit 37 of 1991 are my landlords, or the plaintiff of title suit number 128 of 2012 are my landlords, or is my landlord.
In 37, there is already a eviction decree.
Yes, and I have preferred appeal against it.
And
And
you are
that
not,
appeal is
and
pending.
you are not pursuing that appeal since 2004.
My lord, the appeal is pending. It is at the stage of, it is at the fag end of its, my lord, conclusion. It is pending, and it is.
How you can implead in that appeal where the present the parties which you are seeking to implead are strangers
In that suit.
in that suit.
My lord, Order 41, Rule 33 for a while.
Read.
If I may satisfy your lordship.
Read. Where is the impugn order?
Impugn order starts from page 97, my lord. It's a longish order. Your lordship will see the operative part from page 116, last paragraph, my lord. Your lordship will find the findings of the learned court below, of the learned appellate court, from page number 116 onwards. Before that, my lord, may I read the provision of Order 41, Rule 33?
Yes.
Power of Court of Appeal. Lordship has got the provision.
Yes, you read.
The appellate court shall have power to pass any decree and make any order which ought to have been passed or made, and to pass or make such further or other decree or order as the case may require, and this power may be exercised by the court notwithstanding that the appeal is as to part only of the decree and may be exercised in favor of all or any of the respondents or parties, although such respondents or parties may not have filed any appeal or objection, and may, where there have been decrees in cross suits, or where two or more decrees are passed in one suit, be exercised in respect of all or any of the decrees, although an appeal may not have been filed against such decrees. Now, this is the provision which we are seeking to invoke, my lord, regarding the power of the learned appellate court.
On what ground your prayer was rejected by the?
Your lordship will kindly see from page 116 onwards, the findings are there. May I just quickly read the, my lord, relevant part, my lord, from 116.
No,
What
where is the reasoning?
reasoning is from 116 onwards, madam. These are the observations that have been made. Before that, the discussions of the entire factual aspect of the case, and from 116 on perusal of the case record. Or your lordship kindly takes page number 118, last paragraph. The appellants have challenged the judgment and order there. From there also, my lord, the reasonings your lordship will find. Well, basically, my lord, the learned court below has rejected my petition on the ground that me being admittedly being a subtenant, or the term used is derivative tenant, could not have claimed any right for impleading or making any amendment in the memo of appeal. But my humble contention is, so far my entitlement as a derivative tenant is concerned, that is a matter of adjudication in the title appeal itself. In the title appeal itself, this issue is to be eventually decided. It cannot be decided in this particular petition, where the learned court below has arrived at the conclusion is that just because I am a derivative or subtenant,
What was your plea before the trial court?
in the suit
37,
that was filed
that-
against me.
Yes.
In the suit that was filed against me, we very clearly, categorically, we stated that we are derivative tenants to the tenants under the original landlords, and with consent in writing from the original landlord, so as to suffice the provision of section 5(1)(d) of the Assam Urban Areas Rent Control Act 1972. That was our specific plea. That was denied. Eventually, my lord, in the eviction suit, the main tenant was the original tenants were arrayed as defendants. We were also arrayed as defendants. So just because the default was proved against the original defendants, therefore we were also automatically covered by the decree of eviction. And my lord, now this decree is sought to be executed in that case, against which we have preferred appeal, and that execution is for the time being staked. Our status as a derivative tenant is a matter of adjudication in the memo in the title appeal, which is pending and which is yet to be decided. Not taking that cue from my lord, the objection raised by the other side, the learned court below has rejected this petition, saying that because we are subtenants.
In title suit number 37,
Yes,
the execution has been stayed.
yes, because of the pendency of the title.
And in title execution number 11,
There is nothing stayed, my lord. That is open.
that you are not.
That I had
accept-
preferred this order 21 rule 96, but that is not
They
stayed.
are issuing notice.
There. My lord, in another aspect that, my lord, I'll just beg to draw your attention to it, is regarding respondents number 1 and 2. They are the acclaimed landlords at page number 3. Page number 3.
Okay, before issuing notice, what error has the
The jurisdictional error. My lord, the jurisdictional error that has crept up, my lord, is on account of the fact that while adjudicating the memo of appeal, now, if these developments which have taken place after the filing of the memo of appeal, now, if these are not allowed to be incorporated by invoking the provisions of Order 6, Rule 17, to the extent of allowing the amendment. Now, these aspects are things which will remain untouched, and this will eventually, my lord, lead to another proceeding against the order or eventual order. that
who
will
are
be-
the respondents in this case?
Yes, your lordship kindly sees page number 3.
Respondents are the
1 and 2 are the,
respondents of title appeal number 30.
yes, those subsequent litigants in the subsequent suits, those are not parties in this revision
in
or
this-
no,
Okay.
because they are yet to be brought on record. My lord will kindly
Lord
see what.
Mr. D. Chakravarti, learned counsel for the petitioners. This revision, this application under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated 2/9/2025 passed by Learned Civil Judge Senior Division number 2 Kachar Silchar in Misjay case number 77/2021 in connection with title appeal number 30/2004, which arose out of title suit number 37/1991, whereby the prayer of impleading parties in appeal made by the present petitioners, as well as prayer for amendment of the memo of appeal made by the present petitioner was rejected. Issue notice to the respondents. The petitioners shall take steps for issuance of notice upon the respondents within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
I am praying for stay of my title appeal, the proceeding of my title appeal. My title appeal, I am praying for stay of the further proceedings.
Although notification, I am instructed by respondent number 1 to appear in this case, no, there is no caveat. Respondent number 1.
You filed Vakalatnama?
Yes, so it is very lordship in the course of the day I will file a
Okay.
So he accepts notice for 1, 2.
respondent number, yes, 2 also, but you should have to file suppose punishment copy. For 1 and 2 also I will be filing.
No, stay is not required in this case. Your original grievance is against the order passed in TS 37. That may continue if we find ultimately,
It has been 21 years lordship.
Yes.
What I'm
no stay.
what I'm asking for is stay of proceeding of my title appeal. It is not going to
No.
prejudice them, my title
No,
appeal. That I'm
because in that title appeal, you have also obtained stay in the execution.
the education.
Then you, that stay, if that you are ready to vacate that state, we'll give you stay in the title appeal.
Thing. If this.
This stay will be operative as by meaning thereby that the relief which you took in that title appeal will be automatically be vacated. Then we are ready to,
But so far my petition now that the order that is impugned. If
No,
before
no
adjudication
stay.
by the Honorable Court. One aspect before adjudication, because since your lordship is issuing notice, my lord is not dismissing my petition. No.
Should
before
I dismiss it?
No, what I'm saying is before adjudication by this Honorable Court on this aspect, if this title appeal is eventually heard, my lord, my revision becomes infructuous.
It would be good if it is heard because it is pending for last 20
Notice for under urban areas and control.
years.
No, that is there. my
Landlord
lord,
is
but
defined
this
under urban
issue-
areas. He is the
this
landlord.
issue will remain unaddressed, my lord.
No stay, because this is heard. Mr. S.D. Purkasta, learned counsel appears and submits that he has been instructed by respondent number 1 to appear in this case, and he would be filing his Vakalatnama during the course of the day. In view of his submission, learned counsel for the petitioner is directed to furnish copy of the petition along with the annexures to the learned counsel during the course of the day. List, instead of 4 week returnable on, I'm giving a fixed day. This is a very old pending case. 14th of November.
My lord, so far respondents number 6 to 10 are concerned, my lord. 6 to 10, my lord, may be allowed to take steps by only usual process. They are not necessary parties, but they were parties in the appeal and in the suit. That's why they are here.
No, you take also through registered post.
6 to
We-
10, 6 to 10 also.
Otherwise, we may not be able to draw presumption.
Well.
list accordingly.
Obliged.
I think
Mid-region Lordship. Lordship, the short point involved here is that Lordship, we were not allowed to file the written objection. Subsequent to Lordship 90 days period, Lordship in a similar matter within the same parties Lordship, notice was issued. And Lordship, this matter is fixed after 4 weeks. Same parties Lordship, that was as regards the written statement Lordship, this is for written objection.
Written objection in what matter?
Lordship, it was not allowed. Lordship, we filed a petition stating that Lordship, due to our sickness. she could
No,
not
where is
file-
the impugned order?
Lordship, it is at page number 19, Lord. Annexure B,
Page 19.
19, Lordship, Annexure B. If I may read, Lordship.
Yes. No, why it was, you, what was the petition filed by the other side?
Lordship, I am for the defendant, Lordship. I am the sole defendant of this matter. Lordship, I approached this court at a related point of time, and that by that, Lordship, we filed a petition on 23/6/2025, stating that due to sickness, the learned counsel could not be informed that today we have to seek an adjournment. Lordship, we filed a petition and that was written.
Petition where, in which
In
matter?
the trial court.
In what matter?
Lordship, we.
In the
stated-
suit or in the
The
miscase?
suit, Lordship. In the suit, and in the present matter, Lordship, it was in the miscase also. Two
In
petitions,
the
Lordship.
miscase, what relief was sought for by the
Lordship, there was an injunction. against the
injunction?
property.
Injunction was granted.
Lordship, that has not been granted, but it is still fixed for hearing. Lordship.
It is fixed for hearing,
Hearing.
but you were not granted time to file
File
objection.
the written objection.
Now you want to file
We
objection.
file an objection and Lordship in the main suit, Lordship, we had filed another petition that is before my lord. Lordship, in that matter, notice has been issued by this. Written
No,
statement
we are
also-
not looking at that matter.
In that,
I-
Lordship,
if-
90 days period was expired. we could not
Because
file
in
any
miscase, urgency may be there.
Lordship, there might be some urgency, and matter is fixed for, still it is fixed for hearing. Lordship.
What was the ground for rejection of your
Lordship,
prayer
if I
for
may-
seeking injunction?
Lordship, in fact, Lordship, we produced a medical certificate. Lordship, it goes to show that that was medical certificate dated 17/6/2025, and the court took a distorted view in the fact that on 23/6, when the matter was fixed, you did not file the petition stating that on 23/6 also you were unable to appear before the court and file the written objection. That was in fact. And Lordship, if my lord looks at the.
You pay some cost,
Lordship, I'll pay.
you
I
pay,
pay.
you will allow your petition
Me.
without issuing notice.
Lordship,
When is the next date?
Lordship, it's on 3rd of November, Lordship.
How much costs?
Lordship must be liberal because Lordship, she has been suffering from this diagnosis, Lordship, for more than a year or so. And Lordship, most probably she has gone a uterus cancer. Lordship, I will produce the entire
You
document.
pay 5,000.
Lordship, can must be some liberal cost. So I'll do pay, Lordship, if my lord is of that considerate view. Lordship, if it is liberal, Lordship, I'll definitely. Lordship, I leave it to my lords, Lordship.
Because if we keep this matter pending,
Definitely, Lordship, it would take some time, Lordship. So if my lord consider this, Lordship, we'll pay and we'll file the condemnation delay with it. Lordship, it's on record, in fact. The written objection we have already brought on record also, Lordship. It was not taken on record due to the fact that Lordship, she took a distorted view, the trial court took a distorted view that it is not allowed.
heard Mr. H. Betala, learned counsel for the petitioner. What is the subject matter of the case?
Lordship, it is regards the property, Lordship. Lordship may have it at para number 3, Lordship. That she was a tenant, Lordship, the plaintiff was a tenant there and the property belongs to the wife. Lordship, now they have, due to the marital discord, they have got separated, Lordship.
Who are you?
I'm the wife, Lordship. I'm the defendant in the matter and the plaintiff is a tenant over there.
Plaintiff,
my
your
property.
husband?
He's my husband. So
Okay.
he's taken a view that we had separated the entire properties and she is no longer a landlord and then she, if I may read, Lordship, the facts
No, no.
at para number 3, Lordship.
This application under Article 227 of the Constitution of India has been referred by the petitioner Srimati Renu Devi Jain, impugning the order dated 5/8/2025. What is 23/6?
Lordship, the consequence.
You are basically agreed with 5/8.
Lordship, basically 5/8 and 23/6 was the date when she did not allow us to file the condonation delay on the next day. On 4/8, we approached this court, filed a petition stating that this was the reason. On 23/6 we could not file. The honorable could be pleased to condone the delay and then.
5/8/2025. Passed in Miss J case number 76/2025 in connection with title suit number 30/2025. Passed by the Court of Learned Civil Judge Junior Division number 4, Kamrup Metro, Guwahati, whereby the prayer for accepting the written objection. Why condonation of delay?
Actually, it was beyond the period of 90 days, Lordship. The written statement could not be filed in 30 days, Lordship. This could not be filed.
But section 5 is not maintainable.
Lordship, the council, Lordship, he preferred a petition that is at page number 100 and.
Alison last
Lord.
time. Written objection filed by the present petitioner in the Ms. J case number 76/2025, where the respondent Shri Mukul Kumar Jain, who is the husband of the present petitioner, has sought for an interim relief in the form of temporary injunction. Stop. Learned counsel for the petitioner has submitted that though the petitioner, you produce the documents before the trial court, medical documents.
Lordship, that is at page number 115, the petition which was preferred. Lordship, under the last very page of my annexure, Lordship, 120. Lordship, this is the document which was.
Though the
produced.
petitioner had filed medical documents showing the reasons for, on 23rd, you could not appear,
We could. Lordship.
showing the reasons for our non-appearance before the court,
Lordship, in fact, 23/6 we appeared, but we could not file the written objection on that day.
showing the reasons for not filing the
Written objection.
written objection on 23/6/2025. He submits that on next date, that is 5/8/2025, the petitioner had, though submitted the written objection, it was not taken on record by the trial court. Learned counsel for the petitioner has submitted that the hearing of the said Miss case is fixed on 3/11/2025. And if the petitioner is not allowed to submit her written objection, she would be highly prejudiced. Stop. I have considered the submissions made by learned counsel for the petitioner and have gone through the materials available on record. Since the petitioner has already filed the written objection, it is there in the record,
This please with the record, Lordship, para 7, I've made a categorical statement that it is still. on
already
record.
filed the written objection. And it is there in the record of the trial court in Ms. J case number 76/2025. This court is of considered opinion that if some compensatory cost is awarded to the respondent, the ends of justice would be served if the written objection filed by the petitioner is taken on record and the matter is heard finally on the next day by the trial court, taking into consideration the pleas taken by the petitioner in her written objection. Hence, this court disposes of this revision petition without issuing notice to the respondent with a direction that the trial court, with a direction to the trial court to take on record the written objection filed by the petitioner in Ms. J case number 76/2025 on 8/5/2029, 5/8/2025, subject to payment of rupees 2,000 to the respondent on that, on the next date fixed. This civil revision is accordingly disposed of.
And deeply observed. Till nine.
And also in this case, actually, we have, I'm the plaintiff or and then the plaintiff has, in this case, the dependent number one has already filed their WS and counterclaim. So in that counterclaim, we have, the counterclaim, we have said that the counterclaim has not have any locus standi. So we filed a mixed case in that, order 711D. And that was been.
No,
dismissed.
I am not getting you.
Yes.
You are the
The
plaintiff.
plaintiff, and in that case, defendant number one has filed their written objection and written statement and WS. Counterclaim, sorry,
Written statement and counterclaim.
counterclaim. In that counterclaim, we say that counterclaim has no locus standi because their cause of action was wrongly pleaded. And my lord, actually, the title suit we have filed, it was basically for declaration that they do not have any. Actually, my lord, can you see page number 13? In which they are, page number 13, it's a Jamabandi copy.
No, before going into fact, what is your case?
My lord,
Why have you approached this court? That you have to address in
Yes.
brief.
on 21/8/2025.
Which order you are impugning?
Yes, 21/8/2025.
Page number
Page number 50.
50.
On the day, civil judge number 2 has rejected my miss case, miss J case number 845 of 2024. It was arise from the petition that I filed under order 7 rule 11D.
Rule 11D. What is Rule 11D?
My lord, so, is violation of the act, my lord, it's going by violation of the act.
Read Rule 11D. Take CPC.
Wasting of time.
CPC. What is Rule 11D? Rejection of plaint on what ground?
If it is violate some of the acts.
No, read the language. If it is barred by law. Or what is the language? Yes, please read. Order 7, Rule 11D. where the suit appears from the
Yes, from the
statement
statement of
plained to be
plaint
barred by any
any
law.
law, yes.
Where is your petition? By which law it is barred? Have you mentioned
My
in your petition?
say, it's actually the.
Where is your petition under Order 7, Rule 11, which you have filed before the trial court? Where is the
It's in
order?
Page number 38,
Page number?
38, Annex F5.
By what law it is barred? Where have you mentioned?
Yes, my lord, actually, we have elaborately stated that they are asking for adverse position. The
When you are pleading, when you are taking plea that it is barred by Rule 11D,
it's
which
by
barred by some law.
yes,
By what law it is barred? Some legal bar is there that
Yes.
you have to state in your petition. Unless you have stated that, the trial court has rightly rejected your prayer. This is liable to be dismissed.
yes, my lord, that is one thing in section, paragraph number 6. The defendant number 1 is paragraph number 1 of the counterclaim stated that existence of oral agreement of sale and no proof of transaction of money, hence. So it is like transfer 53 A transfer property.
By what law it is barred? You have to specifically state the law if it is barred by law. If rejection is sought for under Order 7, Rule 11D, then you have to state that it is barred by this law, that law, that law. You have not stated that. And the trial court has rightly rejected that.
The trial court has stated that their rejection ground is like this. My lord, that the owner decided to put the defendant in possession of the suit. And since then, the defendant remained in the position. My lord, it is they are indicating that there was a kind of permissive position.
No,
in this
we are
case-
not going into facts. In the impugn order, you read page 52.
Yes,
Page 52, last paragraph.
there is a instant petition. It is in that it is nowhere stated that the petition is as to how counterclaim is barred by any law. It is in
Yes.
that. My lord,
That unless you state that, how Rule 711D can be invoked?
the effect stated of that only, because we have stated in paragraph number 6 that there was, it was barred by Transfer Property Act 53. And we have also said that it is barred by the rule of adverse position. And also we have stated that there is no cause of action is not there in the case, in the counterclaim, my lord. These are the three statements we have made. And it was very clear. And my lord, it can be seen from the record also, like in the Jamabandi copy, there's
You are the plaintiff in that suit.
and then we have asked for declaration that the mutation order passed by the circuit officer is wrong.
You want your suit to be delayed.
No, that's not the thing. That's not the thing.
Then
This counterclaim will give them some age, my lord, this counterclaim. And then if it has been rejected, that means like the other party, the opposite defendant is going to get some.
whether issues are framed.
Well, it is an admitted position of law, admitted position. They have said that they got the property by way of adverse position. They are in the possession of the property by way of adverse position. When they are clearly saying that they are being put into possession by the owner. And in the Jamabandi copy, it is say that it is by way of sale.
Heard Ms. S. Goswami, learned counsel for the petitioner. this application under under what provision you have filed this revision petition?
227
Where
it's not been mentioned, I have seen that.
that has to be mentioned.
If you ask me, then I can just revise. Find it again, amending it. That provision is not mentioned, I have seen.
Your petition is not maintainable.
Can I withdraw it and find it again?
Heard. Mrs. Goswami Lanin, counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant revision petition. The prayer is allowed.
Pardon?
This revision petition is dismissed on withdrawal.
I'll refine it. Liberty to refine.
She seeks a liberty to
Fine.
file afresh after rectifying the defect. The prayer is allowed.
For admission, item 10.
This appeal is for enhancement. My lord, although it is a case of 2022. My lord, in the meantime, lordship, this case was dismissed for default. My name was not shown in the first list. Subsequently, that has been restored. So at this stage, lordship, notice may go, and my friend is already.
When it was restored,
Restored on lordship 8/9/2020
in which case
in miss case number 2923.
you are appealing for? Heard Mr. M. Khan. London. Counsel for the appellant. It appears that this appeal was dismissed for default on 31/10/2022. However, by order dated 8/9/2025, passed in MC number 29/2023, the appeal was again restored to file. Let the notices be issued to the respondents.
Well, notice has not been
Since-
issued.
Huh?
Notice has not been issued in the appeal.
Yes, in appeal, we are issuing notice.
Yes.
Let the notices be issued to the respondents. Since Mr. K.K. Bhatta has appeared for respondent number 1, no formal notice need to be issued against respondent number 1. However, in respect of how many other respondents are there?
Two other two,
However, in respect of respondent number 2 and 3, the petitioner shall take steps for issuance of notice upon the said respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
PCR paper.
Let the records of MAC case number. What is the original case?
Is 8.
MAC case number 2415/2016 be called for from the concerned motor accident claims tribunal. Registry to take steps for requisitioning the records. List accordingly.
One prayer loss, my name may be reflected in the first list that has not.
Name of Mr. M. Khan may be reflected in the cause list as counsel for the appellant henceforth.
Mason.
Item 11.
My pleasure, Lord. That this revision petition. This revision petition is proper, my lord, against the rejection of my application for, my lord, seeking amendment as well as the implement of, my lord, certain new, my lord, person. That was rejected by implement order dated 28/4/2023. And immediately thereafter, my lord, we approved this honorable court by preferring revision petition under Article 227. The basic ground, my lord, they have raised objection. Suit was filed by us, my lord, in respect of, my lord's food property with a declaration that we are entitled to get some, my lord, share on the ground floor of the building, because my petition in interest was the owner of the land. There was an agreement, and in terms of that agreement, my lord, there was a apportionment of share. And we are made entitled to 30% of the total constructed area. And my lord, they are entitled to 70%. And that was ultimately sanctioned by the complaint authority. Then construction was made. Initially, my lord, as per the agreement, there is no any provision to make any construction on the ground floor.
You're seeking adjournment.
Lordship, I'm seeking adjournment for the lordship.
My lord, this is for the, my lord, seventh time, I think, my lord.
Why?
Lordship, actually, one annexer, which is a power of attorney, we got this morning, today morning, lordship. So I am unable to file affidavit, lordship.
My lord, case is very simple, my lord. They, my lord, raise objection on the ground that they are not necessary party. Whereas, my lord, they said that these persons are necessary party and this person may be, my lord, allowed to be impeded. They file objection saying that they are not necessary party. Now, since they are necessary party, my lord, amendment petition has to
No,
be received.
this is a civil revision of 2023.
My lord,
Now we are in
since
2020.
they are taking time to file affidavit, and every time, my lord, we, my lord, I, my lord.
No
according to-
adjournment.
Lordship, give us just one chance, lordship. I'll file the affidavit next day.
What affidavit?
Affidavit actually, on the last date, contracting council, prayer for to file an affidavit. And today I could not file the affidavit, lordship.
So you lost that chance.
No, lordship, actually,
If you could not file, then you lost that chance.
no, lordship, actually, one annexer, which is one power of attorney, we got this today morning, lordship. And
No, they are impugning only the prayer for rejection of amendment prayer.
just to give us one chance, lordship.
When will you file?
On the next day, after 1 week, is enough, lordship.
Yes.
Perhaps, my lord, immediately after the reopening. What's the? 994 from calendar. Okay. Doing that. My lord, except, my lord, 27, 28, 29, these 2 days, my lord, I will be out of station.
Heard Mr. A.K. Purkasthar,
20,
learned
20.
counsel for the petitioner. Also heard Mr.
Huda,
A. Huda,
Huda.
learned counsel for respondent number
1.
1, who is appearing for authority. What is your name? S. Bosak, appearing for respondent number 2. And Mr. K. R. Padkari, appearing for respondent number 3. Who else is there? Learned counsel for respondent number 1 has prayed for some time to file an affidavit in opposition in this case. Learned counsel for the petitioner conceded to the same. Hence, prayer is allowed. When will you file?
Otherwise convenient for all the parties, that the matter be listed on 23rd.
Let this matter be listed again on 23rd of October.
Right. Till that time interim order, my lord.
The interim order shall continue till
Obliged.
next.
My lordship make an observation that let it be a last chance for them. Otherwise, on next day they will make the same prayer.
Yes.
Wait, please, your lordship. Lordship, this is an MSC appeal by insurance company, my lord. Basically, my lord, my ground is that the deceased person,
Notice has not been issued, na?
for the first time in this conference.
Delay was there.
Delay was condoned earlier, my lord.
Heard Mr. T. Kolita, learned counsel for the petitioner, learned counsel for the appellant. This appeal, why are you preferring the appeal?
Yes, my lord. My lord, here, my lord, the deceased person was some government employee. And there is a scheme, my lord, that if he dies in harness,
Your
my lord.
insurance company, na?
Yes, my lord.
Where is your memo? This appeal under section 173 of the Motor Vehicle Act 1988 has been preferred by the appellant insurance company, impugning the judgment and order dated 10/2/2025 passed by the member Motor Accident Claims Tribunal Vishwanath in MSC case number 37/2018. Stop. Let the records of MSC case number 37/2018 be called for from the concerned Motor Accident Claims Tribunal. Let also notice be issued to the respondents. The petitioner shall take steps.
May I make to interrupt, lordship? Lordship, respondent number 1 has appeared. P. Neu, Mr. P. Neu. He was here, my lord. And
Where?
he was there for some time back, my lord.
But today he's not there.
He's not there. He'll take steps.
You- Appellant, kill the last line. The appellant shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
I is there for stay, my lord.
Say after appearance of the in I also issue notice. Same line up. List accordingly.
Until 14.
Please, lordship. I'm appealing for the appellant claimant, and this is for enhancement. So.
Enhancement.
For enhancement, there's an.
Heard
indication-
Mr. R. Goswami, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act 1988 has been filed by the appellant Shri Akhil Das, praying for enhancement of the compensation awarded to him by the judgment and order dated 20/12/2024 passed by learned member Motor Accident Claims Tribunal number 3, Kamrup Metro Guwahati in MSC case number 1890/2019. Let the notices be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let also the records of MSC case number 1890/2019 be called for from the concerned motor accident claims tribunal. List accordingly.
Yeah, please, Your Honor. Lordship, this appeal is preferred against the judgment and order 3/6/2025 of MAC case number 1452.
Dismissed.
Dismissed.
It was dismissed.
Yes, because the findings is that claimant did not exhibit the FIR and the SASI.
Heard Mr. H.K. Sharma,
Z, sorry,
G. Sharma, G.
Z for Goa.
Heard Mr. G. Sharma, learned counsel for the appellant. This appeal under Section 173 of the Motor Vehicles Act 1988 has been filed by the appellant Tafiqul Islam, impugning the judgment dated 3/6/2025 passed by learned member Motor Accident Claims Tribunal number 3, Kamrup Metro Guwahati, in MAC case number 1454/2018. Let the notices be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondent by registered post with AD, as well as by usual mode, within 7 days from the date of this order, returnable after 4 weeks. Let the records of MAC case number 1454/2018 be called for from the concerned tribunal, the registry to take steps for requisitioning the records. List accordingly.
For enhancement, Lordship.
Heard Mr. M. Khan, learned counsel for the petition. Appellant. This appeal under Section 173 of Motor Vehicles Act 1988 has been preferred by the appellant, praying for enhancement of the compensation awarded to the appellant by judgment and award dated 25/6/2025 passed by the Motor Accident Claims Tribunal, Bongaigaon, in MSC case number 114/2023. Issue notice to the respondents. The petitioner, the appellant shall take steps for issuance of notice upon the respondents by registered post with AD, as well as by usual mode, within 7 days from the date of this order, returnable after 4 weeks. Let the records of MSC case number 114/2023 be called for from the concerned tribunal. List accordingly.
Item 17.
Wait, please, Your Lordship. The appeal by insurance company member.
Yes.
Lordship, here, my lord, the ground of appeal is that the deceased person was,
What you are seeking, why you have preferred appeal?
my lord, the deceased person was traveling in a motorcycle, my lord. And that motorcycle was insured under Act policy,
Act only
Act
policy.
only policy. So being the pillion rider, he was not at all covered under the policy, my lord. The evidence was laid, pleading was there. So despite that, my lord, liability has been fastened upon us, my lord. That is why we are here.
Heard Mr. T. Kolita, learned counsel.
Myself, for our respondent number 1, my lord.
Have you filed Wakalatnama?
My lord, not just today, I have.
What is your name?
B.R. Das, my lord. I was the claimant advocate, my lord.
Also heard Mr. B.R. Das, learned counsel for the respondent number 1, who submits that he shall be filing his wakalatnama
Yes.
soon. This appeal under section 173 of Motor Vehicles Act 1988 has been filed by the Appellant Insurance Company, impugning the judgment and order dated
19/6/2025.
19/6/2025, passed in MSC within bracket death, case number 9/2022 by the Motor Accident Claims Tribunal,
Not copy.
Lakhimpur.
Lakhimpur. Issue notice to the respondents. Since learned counsel for respondent number 1 would be filing his wakalatnama shortly, no formal notice need to be
Yeah.
issued to
Extra copy maybe.
the respondent number 1. However, the appellant is directed to furnish the memo of appeal along with the annexures to the respondent number 1, to the learned counsel for respondent number 1. As regards respondent number 2 is concerned, the appellant shall take steps for issuance of notice on the said respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Also, my lord, I is there for stay.
You are claiming,
Yes, my lord.
you have anything to say on stay?
My lord, I will file an objection because I have not received any copy.
Okay, heard Mr. T. Kolita learned in IA. T. Kolita learned counsel for the applicant. Also heard Mr.
B.R. Das, my lord.
B.R. Das, learned counsel for
Respondent.
respondent number 1, who has submitted that he would be filing his wakalatnama very soon. This application under Order 41, Rule 5 of the Code of Criminal Procedure 1908 has been filed by the applicant to praying for stay of the execution of the impugned judgment dated 19/6/2025, passed in MEC death case number 9/2022 by the Motor Accident Claims Tribunal, Lakhimpur. Learned counsel for the respondent number 1 has submitted that he may be allowed to file a written objection in this case. The prayer is allowed. Issue notice to respondent number 2. The applicant shall take steps for issuance of notice upon respondent number 2 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List the matter accordingly.
Marshal.
Court hearing under order 41 Rule 2. Item 18. Item 18. For 18.
None has appeared for the appellant on call. List this matter again in the next week on a date to be fixed by registry.
19.
Waiting to sound.
May I please?
Just a minute. 19.
May I please, your lordships?
Yes,
This concurrent findings, lordships. I am the defendant number one, principal defendant, and plaintiff suit was declared. Plaintiff claimed her right to interest on the basis of a possession certificate dated 5/12/1988, Exhibit 1. And he claimed, the plaintiff further case is that the defendant was allowed in the tenanted premises, in the suit premises as baratias, a monthly tenant for a period of 7 years, as per agreement dated 5/10/2021, that is Exhibit 2. Defendant number one, I am the defendant one, appellant, before we contest the suit by filing written statement as well as counterclaim. Performer defendant number also filed written statement as counterclaim. Both the counterclaim dismissed. And trial, here is the case, lordships. Here, the main question is that, lordships, I have taken the question, lordship, that not has to be answered, lordship.
you have
Going to
mentioned
permit
the
it.
substantial question in your memo of appeal.
Yes, I provided to three also, lordships.
Why are you providing when it is already there in memo of
Yeah,
appeal?
lordships, that question number one,
Accustomed by your habit.
yeah.
Oh,
Question number one, lordships.
yes,
That is whether the findings of both the courts below are correct, proposition of law of Exhibits 1 and 2 in view of section 101 and 30 of the Indian Evidence Act.
this is not substantial question of law.
But 101, they have to comply, lordship. And then even section, when I denied the claim, lordships, these are the subsequent of law, lordship, 101. Plaintiff has to prove her case. She failed to prove. And I, lordship, objected regarding the execution of Exhibit 1 and 2. Specific, my case is there, lordship, kindly see.
These are matters of fact.
But and second question is that, lordships, regarding whether the judgment. Second question is that, lordship, whether judgment decree passed by Honorable Courts below are perverse without deciding perverse by not following the provisions of Order 14, Rule 1 and 2 of the Court of Appeals. Important vital issues not been framed. I disputed the Exhibit 1. That question not been formulated. And in this case, lordship, also, plaintiff not discharge her verdict.
No, you are now taking plea that some issues were not framed.
Framed, lordship.
In second appeal, you are taking this plea.
That has to be, lordship, that in respect of defendant number 2, performed defendant, that question formulated, but it was not answered.
Show me.
Yes. Lordship, page 60 is the issue, lordship, the trial court judgment.
Whether you raise that before the first appellate court.
First appellate court, lordships. First appellate court question is that, lordship, that is,
No, whether you raise this plea before the first appellate court. That some issue
lordship,
was,
since there is a specific question, lordship, page 55, may I raise, lordship, kind of looked into, lordship, page 55. First appellate court is the final court, lordship, take all the facts and law, lordship, page 55, paragraph, bottom paragraph, Roman 2, lordship. That is a specific, my case. Lordship got it, page 55, Roman 2, bottom. For declaration of so-called agreement dated, executed on 5/10/1, marked aggressor 2, which is without the signature of principal defendant, and post certificate marked as aggressor 1 be declared as illegal, fraudulent, and void ab initio and inoperative in law, and nor right can be approved on behalf of the plaintiff on the basis of the fraudulent and collusive documents. My plaintiff's case, the defendant's case, can we see, lordship, paragraph 12.
defendant had any counterclaim?
Yes,
Defender has a counterclaim also, Lordship.
Counterclaim was there.
Yes,
Okay.
not discussed in the trial court also. The page Lordship will find page
Yes.
75, Lordships. Issues in counterclaims. Next page, Lordship, in view of the issues decided in plaintiff suit in favor of plaintiff, the counterclaimant number 1 is not entitled to any relief as paid for. In the light of the discussion and decisions made, the issue number 4 in the plaintiff suit, the plaintiff has title over the suit land, but the plaintiff is in permissive person having the right and interest allowed to be allowed by the counterclaimant number 2. So the plaintiff or the party is not liable to evicted from the suit land. According to all the issues and counterclaimant is decided legally. And the appellate court tried to discuss in both the counterclaim of defendant number 1, there is a appellant and the counterclaim. But in respect of counterclaimant number 2, Lordships, no issues are framed, so nothing discussed also. So an order 41 rule that is also attracted in this case also. Yes, to answer the appellate, first court is the final course of facts law, Lordships. Nothing discussed in this. And
This page number 75 is of trial court judgment.
trial court judgment.
Where is the appellate court judgment?
Appellate court judgment is starting at page 44.
No, what is
Lordship.
your plea now?
Page 97, Lordships.
What is your plea?
My plea is that, Lordship, since I disputed the possession certificate, it was created by the plaintiff. Plaintiff has to prove her case. She has not proved her case. Burden shifted to us. Because defendant number 2 not only evidence not cross-examined her, but I cross-examined her, but no question, but not decided in respect of my case. Since I questioned the exhibit 1 also, nothing discussions in both the case. Neither the trial court nor the appellate court. And in respect of exhibit 2, I disputed, I have not executed any agreement. No agreement was executed between the plaintiff and defendant. I have not
No,
proved any
what is the
signature.
case? You were possessing
I am possessing since
a
1986.
plot of land. What
Plot-
you are possessing?
Plot
Plot of land or
plot
room?
of and house. The house I constructed. I myself.
What is the area of that house?
area of the house? my lord? Land.
Okay, forget it. You are possessing.
I am possessing.
Then
Since
the
1886,
plaintiff filed
plaintiff
suit for recovery of possession and
for
declaration.
I stated interest and recovery of possession, stating that I am defaulted, I have not vacated the premises in view of agreement dated 2001, that is for a period of 7 years, in spite of period clause. But I denied that agreement. No agreement was, I have not put my signature.
What is your claim over the suit land?
Suit land is claimed in the year 1986. I obtained the suit land from the father-in-law of the plaintiff.
On by what basis?
As a tenant,
Tenant.
as a
Okay.
tenant, by monthly tenant, and paid regularly. After death of the father-in-law of the plaintiff, husband entered the suit of the suit land, and thereafter the husband sold the suit land to me by a sworn levy, that is exhibit A. So I am in since his possession, Lordship.
Now, what was held by the trial court?
Trial court held that, yes, page, Lordships, page 67. Bottom, Lordships, the findings of exhibit 1 and exhibit 2. Paragraph 19, page 67. The recital of the plaint reveals that the plaintiff claimed right, title, interest, and possession on the basis of permissive possession and long adverse about the suit land. The plaintiff stated that the suit land and house is within the land of Gambira Tea Garden, and she was allowed to leave about the suit land by manager Gambira Tea Estate. Exhibit 1 is the policy certificate issued in the year 1998 by the manager Gambira Tea Estate. The counterclaimant number 2, Gambira Tea Estate, denied the plaintiff's statement and stated that the plaintiff was not allowed to leave over the suit land and never issued any policy certificate in favor of plaintiff, which is fabricated. The pleadings of the counterclaimant number 2, performance number 2, the Gambira Tea, reveals that the husband, the plaintiff, Hansho Narayan Baroi, was workers representative during the period of 1983-84, and he was staying with his family members at workers' quarter of Gambira Tea Estate. The said Hansho Narayan Baroi expired on 22/12/2010. The defendant pleading reveals that the defendant was allowed to leave over the suit land by Shiva Prasad Baroi in the year 1986, and Shiva Prasad Baroi was the father-in-law of the plaintiff Sudama Baroi. Both the pleadings, the plaintiff and the defendant, and defendant reveals that the plaintiff's husband and father-in-law had been residing in the land of Gambira Tea. The plaintiff further stated that after death of her husband, she inherited the suit house and residing till date. Hence, the plaintiff has been residing over the suit land since her marriage, and the plaintiff was allowed to possess the suit land by the performance defendant number 2. Exhibit 1 is the policy certificate issued by the manager Gambira Tea. The counterclaimant has denied the issuance of policy certificate Exhibit 1 and stated that manager of the Gambira Tea never issued the policy certificate Exhibit 1, but the performance defendant counterclaimant 2 neither.
You are respondent number 2.
I am 1.
Defendant number 1.
Defendant number 1. I also disputed that Exhibit 1. My specific case also.
What was held by the trial court?
Lordship, this paragraph, Lordship, this. But the performance defendant counterclaimant neither cross-examined held that in respect of my case, nothing discussed. Only in respect of the performance defendant not cross-examined the defendant plaintiff. So plaintiff has proved Exhibit 1. So here the disputed question, plaintiff has to prove her case. She failed to discharge as per provision of section 1. Firstly, discharge burden lies upon the plaintiff.
No, that is you are submitting. How, what court held?
Yes. Hence it presumed that the plaintiff obtained birth certificate from the authority of Gambira Tea, and according the plaintiff is in permissive process of suit land, mere denial is not sufficient to review the presumption. The main dispute is not with the performance defendant. The plaintiff filed the instance suit only against the defendant number 1. As the performance defendant 2 allowed the plaintiff to stay about the suit land, and the plaintiff is in permissive possession over the land of performance defendant 2. And the plaintiff has no relief against the performance defendant number 2. Now let me come to the main point in the dispute for adjudication of the instant issue, which is whether the defendant is a tenant of the plaintiff. They directly discarded my case. The state court came to Exhibit 2. Exhibit 2 where I disputed. Since I have not put my signature, since section 80 of the Evidence Act, signature has to be verified, Lordship. But in the instant case, nothing has been done, Lordship, in both the court. Let me come to the main point in dispute for execution of the instant issue, which is whether the defendant is tenant of
No,
the
no,
plaintiff.
instead of reading the whole judgment,
Lordship, that exhibit bottom, Lordship, will find last but 4 line, Lordship. Exhibit 2.
what is Exhibit 2?
Exhibit 2 is the plaintiff exhibited as agreement. That
Agreement between?
agreement between the plaintiff and defendant number 1.
Okay.
This is LS that agreement.
What
I
agreement?
disputed.
What agreement?
Regarding I obtained the tender price as a baratia. I disputed. I have not entered. I have not made any agreement with the plaintiff. I am residing in the suit land since 1986, and subsequently I purchased the suit land from the husband of the plaintiff.
No, the trial court held that
Held that.
you cross-examine, but in spite of
Cross-examined, but why the finding, Lordship? Exhibit 2 is that the bilateral agreement. I have perused the Exhibit 2. One Sudarshan Hajam is attesting witness, PD1 is cross-examined by the defender side. It is a lengthy cross-examination, but nothing materials is found to contradict the evidence of PW1. The plaintiff side examined another two numbers of witness, prove the execution of exhibit 2, PW3 and PW4. PW3 is the attesting witness of exhibit 2. During cross-examination, PW3 stated that Gombeti is the owner of the suit land. PW3 is evidence reveals that the put is signature on the exhibit 2 as witness, and exhibit 2 was written by Anantalal Jadhav is his presence. Anantalal Jadhav was examined PW4 and stated the exhibit 2 is the written by him, which is a lease rent agreement and put signature on the exhibit 2. Exhibit 213, exhibit 13 are signature, exhibit 2 PW4 further stated that in exhibit 2, PW4 further stated the exhibit 2 was executed by.
But court held that it was proved.
Import, but I denied that I have not entered any agreement with the signature has to be proved. I have not put my signature. Kindly see my prayer also, counterclaim, and my statement also. I have not put signature, Lordship. Prayer of my counterclaim, Lordship, and see the signature.
No, other witnesses have proved that
Other witness of the plaintiff that I put. Since I deny, court has to compare the signature whether I have not
No,
put any signature.
No, if court comes to a finding through other witness, other evidence on record, it is on the basis of preponderance of probability.
But in respect of my evidence, that was not been discussed, Lordship. I straightforward discussed, Lordship. I received a plaintiff evidence. My evidence not properly discussed. Also. That's why order for rule 31 is also required. Only stated details cross-examination. But what are there? The details also nothing else in both the court.
So what is the substantial question
The
that
substantial court.
it is perverse?
Yes, there is. That's why it is perverse, Lordship. Order 41 rule 31 is also, and as well as second.
What is the state of execution case?
No execution case is still not been filed. It's a
Not been
judgment of
filed.
16/8/2025.
Heard Mr. F.U. Bordhuya, learned counsel for the petitioner, learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure 1908 has been filed by the petitioner, by the appellant,
Yeah.
Usman Ghani, impugning the judgment and decree dated 16/8/2025, passed in title appeal number 16/2024 by the Court of London Civil Judge Senior Division Sri Bhumi in title appeal number 16 Sri Bhumi, whereby it upheld the judgment and decree dated 10/5/2024 and 13/5/2024 respectively, passed by the trial court, that is the Court of London, Civil Judge Junior Division number 1, Karimganj, in respect of title suit number 187/2011. So, after perusing the materials available on record and hearing the learned counsel for the appellant, following substantial question of law is formulated in this case. Whether the judgment and decree passed by the First Appellate Court and the trial court are perverse to the extent that while reaching at the conclusion, it did not consider the evidence tendered by the defendant number 1, within bracket appellant herein. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Returnable not after 4 weeks. Returnable on 17th of November 2025, list accordingly.
LCR.
Yes. Let the records of trial court as well as first appellate court be requisitioned. The registry to take steps for requisitioning the records, list accordingly.
One round, any other substantial questions that may be found at the time of hearing?
Law is there. Law will take
To
care
I,
of.
to IA is there regarding, since I am pursuing the land in question lawsuits, the injunction is required, but status quo may be maintained.
No, what status quo? You have just now submitted that no execution case has been
Yes,
filed.
but in view of the judgment lawsuits, they are trying to dispose us.
No, they
powerful
will not
party.
try. They will file an execution case.
But they are the powerful party. The earlier occasions, prior to filing the case,
I will be dismissed if you insist.
lawsuits, issue notice.
Two IAs are for,
Yes, one stay of the impending judgment and decree.
in both the IAs, issue notice to the respondents.
Judgment may be stayed, seal lawsuits, admitted the appeal.
No, what is the submission?
Lawsuits notice issued regarding on the following subsequence of law. Appeal admitted. or not.
Appeal is admitted.
Admitted lawsuit.
Yes.
Since lawsuit admitted the appeal, judgment may be stayed lawsuits.
No,
Otherwise, execution process will be.
let the execution case. It is not automatically
Lost,
that appeal is
but
admitted,
they-
therefore judgment will be
but
stayed.
They had other side.
You,
is forward
you
will
have
pass.
submitted that there is no execution case.
Yes, sir. No.
There is
appeal-
no
No
necessity.
execution process yet to be filed. Yes, yes, that is. correct.
Therefore, these two interim IAs are liable to be rejected, but I am
And,
issuing
in
notice,
all lawsuit issuing, but lawsuit all that.
issue notice
Not issuing.
in the list accordingly.
Obliged.
Order item 20.
May I please, Your Lordship? Kindly
David.
peruse the office note dated 13/8/25. Trademark is there. 13/8/25.
13/8/20, yes, what it says?
Regarding usual process notice received by 2C on behalf of respondent number 2 and 2B. And 2C also received.
Who is to see?
Who is the daughter?
As regards other. Heard Miss M. Bhattacharya, learned counsel for the petitioner. On perusal of the office note dated 13/8/2025, it appears that notices sent to respondent number 2A, 2B and 2C by way of usual process, were received by respondent number 2C. The notices are therefore held to be duly served on the said respondents. How many respondents are there?
There are 3 residents.
As regards other respondents, what is the status?
Proforma respondent. Respondent number 2. And I am the respondent number one.
You find out
I am
from
the
the,
respondent number one,
you are for?
Ramlal Jadhav.
No,
I am the respondent number one in the,
you are for the petitioner.
yes, I am the petitioner. Petitioner and defendant number one.
No, whether other respondents have appeared.
Oh, only there are two.
Two A,
defendant-
two B, two C,
Yeah, they are the legal heirs of defendant number two.
and respondent number one.
Respondent number one, they have appeared.
None, stop, none has appeared for respondent number one. This revision petition shall proceed ex parte against the respondents. Let this case be listed in hearing column. The records have called
Records of
in hearing column on a date to be fixed by registry.
interim order may kindly. be-
The interim order shall continue till next week.
Item 41.
May you please the lordship, lordship. What you want to know?
Yes,
Complied with an
you appeared.
appear and selfie also preferred lordship. The order will
Heard Miss T. So learned counsel for the petitioner who has produced the order dated 1/10/2025 passed in CIDPS case number 4/2025 by learned Special Railway Magistrate Guwahati in compliance with the directions of this court.
P10 also lordship order dated 110 was validated.
This petition will be disposed of. This interlocutory application is accordingly disposed of.
Order will be placed.
You require it.
I
Let the orders produced by learned counsel for the petitioner be part of the record and kept in record. Let the order produced by learned counsel for the petitioner be kept in record as a part of it.
oblige.
42.
Yes.
Lordship, I have been preferred praying for extension of the time to appear before the IO, Your Lordship. On 6/8/2025, Your Lordship. That's been granted absolute and I was supposed to appear before the IO within 7 days. However, I have received the certified copy on 12/8, Your Lordship. I have applied for the certified copy and thereafter, due to some medical reasons, the petitioner could not appear before the IO. Subsequently, he appeared on 5/9/2025, wherein and whereby the IO has asked the petitioner to get a fresh order or else they said that he will be arrested. And as such, his statement has not been recorded on 5/9/2025. The copy of the order is at page 18, Your Lordship.
Heard, Mr. Yes, Mr. Das. Let him appear.
I'm not aware Lordship, whether he appeared or not. Lordship.
Heard Mr. G. Bordole, learned counsel for the applicant. This interlocutory application has been filed by the petitioner, namely Manir Uddin, in connection with
Yes.
bail application number 1490/2025. Wherein the petitioner was directed to appear, wherein by order dated, which order? 6/8/2025. The petitioner was directed to appear before the investigating officer of Bongaigaon Police Station, case number 40/2025, within 7 days from the date of the said order. Learned counsel for the petitioner has submitted that the petitioner could not appear before the investigating officer within the stipulated time, as the certified copy of the order was furnished to him only on 12/9, 12/8/2025, and therefore due to some ailment, he could not appear before the investigating officer. He further submitted that the petitioner ultimately appeared before the investigating officer on 5/9/2025. However, as there was no order regarding extension of the time, the investigating officer did not record the statement of the petitioner. The petitioner is, learned counsel for the petitioner has submitted that the petitioner is ready and willing to cooperate in the investigation. And he may be granted a fixed time to appear before the investigating officer. Considering the submissions made by learned counsel for the petitioner, in light of the materials available on record, the prayer is allowed. The petitioner is allowed to appear before the investigating officer within next 10 days of the date of this order and cooperate in the investigation. This interlocutory application is accordingly disposed of. Yes.
In this case, I want to take steps for filing amended petition, but I could not take steps on time, my God. So a 10 days time will be granted as the last sentence.
Heard Mr. P.K. Goswami. This is item number? Heard Dr. P.K. Goswami, learned counsel for the petitioner, who submits that due to some unavoidable reasons, the petitioner could not take steps for issuance of notice or
Filing amended petition.
for filing amended petition as directed by this court, and seeks some more time for doing same. Considering the submissions made by learned counsel, the prayer is allowed. The petitioner may file amended petition within
10 days.
10 days from the date of this order, list accordingly.
Item 22.
Please, your lordship. In this appeal, lordship, the sole appellant expired, lordship. So I have filed 3 applications, lordship. One for delay, IA civil 82, lordship.
IA 82.
For condonation of delay, lordship.
Notice has been served.
Yes, lordship, last order, lordship.
Heard Mr. P. Chakraborty, sorry, P. Bhattacharya, learned counsel for the applicant. Stop. No one has appeared for 83 lagi. Nothing. Learned counsel for the, no, ki likhile? For the respondents, though on perusal of the order dated 17/9/2025, it appears that the notices issued to all the respondents have been duly served. Stop. How much delay was there?
1 4 Lordship, in my calculation.
What is the explanation?
3 Lordship.
Learned counsel for the petitioner has submitted that in preferring the connected
Second,
regular second appeal, the delay of 1
my calculation in 1 4 1 4 Lordship.
141 days have been
1414 days. 1400.
here. You have mentioned 1,420 days. 1,420 days have been caused, and the applicant has explained the delay in paragraph number 3 of the condonation of delay application. Stop. Since no one is objecting to the prayer for condonation of delay, and since grounds for the delay stated in paragraph number 3 of the application for condonation of delay are found to be sufficient, the said delay is condoned. This interlocutory application is accordingly allowed. The registries, this is for
Condonation of delay Lordship.
for
Substitution of legal errors of sole appellant Lordship.
is allowed. The
In substitution petition, I have given the details of the legal errors. Yes.
is allowed. Stop. Substitution petition. Abatement is also there.
Abatement 83.
83 level. Episode. Abatement is 83.
And next one is substitution. Paragraph 3 of the substitution
No,
petition.
but this abatement, whether notice will go
Not requiring, because in delay that is already.
delay, they might have chosen not to appear.
See, delay Lordship that is already served Lordship not required because this is a long pending case 2011 Lordship.
Okay. Heard. Ms. P. Bhattacharjee, learned counsel for the applicant. This application under Order 22, Rule 9 of the Code of Civil Procedure 1908 has been filed for setting aside of abatement of the connected regular second appeal number 47 of 2011 on the death of
Sole appellant Lordship.
sole appellant. It appears that this application has been filed after a period of delay of 1420 days. However, by order passed on 13/10/2025 in IA within bracket civil 82 of 2018, the said delay has been already condoned. The this opposite parties have not appeared before this court in spite of due service of notice in IA number 82/2018. Therefore, notices are not separately issued again in this interlocutory application. Considering the reasons mentioned in paragraph number 3 of the instant application, the abatement of connected regular second appeal number 47/2011 is hereby set aside. Next 85.
Paragraph 3, I have given the details of legal heirs of the sole respondent.
This interlocutory application has been filed by the legal heirs of the sole appellant under Order 22, Rule 3 of the Code of Civil Procedure 1908 for substituting the names of the legal heirs of Syed Muhammad Shafiduddin Saifuddin Ahmed, who was the sole appellant in the connected regular second appeal number 47/2011. The names of legal heirs of the deceased appellant has been mentioned in paragraph number 3 of the instant application. As no one has objected to their substitution in place of the original appellant, comma, the names of the said legal heirs, namely number 1 Shahidur Rahman, number 2 Saida Selima Ahmed, number 2 Sayyid Gilima Ahmed, number 4 Sayyid Alikur Rahman, number 5 Sayyid Taiful Islam, number 5 Suraya Khatun, be pleaded in place of the deceased, be substituted in place of the deceased appellant as appellant number 1 within bracket 1 Roman 1 to 1 within bracket Roman 6. Stop. The substituted appellants shall file a corrected memo of appeal. You will file a memo of appeal in the connected RSA number 47/2011. This interlocutory application is accordingly disposed of. The registry to list the connected regular second appeal after receipt of the corrected memo of appeal.
For final hearing also. In this 2011 matter.
But their notice will go in appeal.
In fact, in original appeal, they have already appeared file Wakalatnama also. The name also shown in the.
Let us see whether for it has been admitted earlier.
Earlier admitted, Lordship.
Okay, in hearing column. List it in hearing column.
Apply.
Item 23.
May it please your lordship. Lordship, as per office note dated 8/10/25, all others are served. Only for respondent number 2, the AD card has not yet come back. Lordship, he can be deemed served is the driver of the other vehicle.
My lord, respondent number 2, mother of the deceased. She was the claimant. She has already expired.
No, she was striked out by order dated 5/9/13. I'm talking about seven. She was striked out, 7 or Karne, 7 to.
Respondent number 7, you have taken steps.
She taken step. The AD card has not come and even the process server report has not come because it was sent by Munsif number 1 Chirang. It can be deemed served lordship because otherwise the appeal is
For,
pending.
for deeming some materials is necessary that you have sent.
Sent by the registry. Lordship can give, ask the registry to provide the postal receipt, postal,
Postal track consignment.
yes. Because we,
But it is 2019, it may not be.
18 matter, 2018 matter, the notice was issued 19.
because it was, first there was delay, then it was admitted in, on 5/9/2019, then we had taken the step lordship. Sorry, no, to beleg gari khana driver. Amar gari khana no.
He is also not necessary, the lordship may deem. to be
Deemed
served,
served lordship.
And matter may be posted for hearing. Because 2018 matter.
Heard Miss R.D. Majumdar, learned counsel for the appellant. Also heard Mr. M. Khan, appearing for respondent number. M. Khan is appearing for respondent number 1. And Mr. A. Datta.
He's no more, then I'll get to put it to me. That's the number 3, Asipan. Name is.
Heard Mr. R.C. Paul appearing for respondent number 3. Learned counsel for the petitioner has, the appellant has submitted that though the appellant has taken steps for issuance of notice on respondent number 7 way back in. When did you took steps?
I think 16/11/2019 lordship because that is.
Way
that
back in the year
Office note lordship 16/11/2019.
2019. However, neither the notices have returned back nor the AD card have been received back. As the steps were taken long ago, it is also unlikely that track consignment report would be available now in the website of the postal department. Hence, she prays for deeming the due service of the notice upon respondent number 7 by registered post. The counsel for appearing respondent do not opposes the prayer. Considering the facts and circumstances of this case, the notice issued to respondent number 7 is deemed to be duly served. As there is an indication in office note that dated 16/11/2019 that notice were duly issued to respondent number 7 through registered post with AD stop. Since this matter is an old pending matter of the year 2018, let it be listed for hearing.
Any date lordship.
Week, no date. Choose a week.
30 of October.
Yeah.
In the first week of November. Oh, this appeal is for against award. You have paid some amount. Okay. In the first week of November.
But in the cross objection, lordship, which they filed, they have not taken steps. So
Then it-
My friends.
Where is
they-
the cross
it
objection?
is there.
They are appearing, Lordship, I will sub the copy.
It
We'll
is there.
dismiss the cross examination objection for not taking steps. Let it be called for.
I will
It is
take a
there,
step.
cross objection.
My lord, no, I will take a
So-
step, Lordship, as my friends
Process.
are appearing, Lordship, that's why, perhaps.
अरे मुख
Okay,
को
I'll
दिया
take a
जाए, मुख
yeah.
को ये मत कर।
46,
Yes,
we are dismissing it.
Lordship, I will take a step, Lordship, they are appearing.
For last 6 years, what you were doing?
Sorry, Lordship, I'll take. a
For
step,
not
Lordship.
taking steps as per court's direction is a sufficient ground for dismissing the.
That, Clement will please you, dash, Lordship, highly, my lord, so I'll take a
Heard.
step, Lordship, today itself. Lordship.
Heard Mr. M. Khan, learned counsel for the cross objector. Also heard Ms. Adi Majumdar, learned counsel for the appellant, as well as Mr. R.C. Paul, learned counsel for
two.
respondent number 2 in the appeal.
No, in appeal, he is free, lord.
Respondent number 2 in this cross objection. It appears that in spite of specific directions by this court, the cross objector has not taken any steps for issuance of notice on the respondent number 1, 3, 4, 5, and 6.
He is myself.
1, 4, 5, and 6. One is
You are
you,
two, you are
No,
two here,
I'm two, yeah. Cross appeal, I am two.
two.
1, 3, 4, 5, and 6. However, learned counsel for the cross objector prays for one last chance in the interest of justice for taking steps. The prayer is allowed. The petition, the cross objector shall take steps within 7 days from the date of this order for issuance of notice upon the respondent number 1, 3, 5, 6, and 1, 3, 4, 5, and 6 by registered post with AD as well as by usual mode. Returnable,
Subjection, Lordship, respondent number 1, my friend, and respondent number 2, my friend. This, and others, Lordship, 3 to
One
6,
cut.
Lordship, I'll take a step.
one Katidigo. List this matter. Then it will go in the 3rd week of November. Earlier matter also 3rd week of
Yes.
November.
Step, respondent number 3 to 6, Lordship, I'll.
Yes, 3 to 6.
Shall you oblige, lord?
24.
Okay, in this case, I am taking 3 days time for taking step of the respondent number 2.
Heard,
Respondent 1 has appeared.
heard Mr. K.K. Bhatto, learned counsel for the appellant. Also heard Mr. M. Khan, learned counsel for the respondent number 1. Learned counsel for the appellants. Appellant seeks 3 days time for taking steps for upon issuance of notice on respondent number 2
By both way, Lordship.
by a registered post with AG as well as the usual mode. The prayer is allowed. Let this matter be listed after 4 weeks.
Item 26.
Lordship, service is complete. We filed the amended cost title as well.
Who is appearing for the other side?
Lordship, respondent number 1, Mr. AMS Mazumdar.
Heard Miss, what is your name?
K Bhattacharya.
K. Bhattacharya, Learned Counsel for the petitioner. None has appeared for the other respondents.
Your Lordship, I'm appearing for respondent number two.
Sorry,
I'm appearing for respondent number two.
what is your name?
See you go.
Mr. C. Gogoi appears for respondent number 2. It appears from the office note dated. No. Yeah, respondent number 1 expired
Yes, Lordship, we have filed the substitution petition.
and you have to issue notice on them.
Yes, Lordship, that has been done, and we have filed the cause title, amended cause title also, and the copies have been served to the council.
To whom?
Mr. AMS Mazumdar.
Learned Counsel for the petitioner has submitted that in pursuant to the directions of this court, the amended cause title of the revision petition showing therein the legal heirs of the respondent number 1 has been filed. She also submits that copies of the amended cause title of the revision petition has also been furnished to the Learned Counsel for respondent. Whether records were called for. What is challenged?
Reports have not been called for.
Now, whether records will be required or not. What is the impugn order?
Lordship, impugn order is impugn order is that's dated 3/12/2021. That's annexed with the same thing and as an extra 3.
Page number? Order 23.
58.
Twenty-eight is a petition.
Lordship, page 33.
Lordship, it is against the rejection of a petition for withdrawal of the suit on the ground of formal. That was rejected.
Small matter. Who is the plaintiff in the?
Plaintiff is the petition.
Let this matter be listed for hearing.
The date may be fixed.
Yes. When? On 8th of November.
Lordship.
8th November.
Obliged.
Lordship, as per the office note, Lordship, the service report has not been received.
What is to be done?
Lordship,
You suggest what should we do?
Lordship, we should, we may wait for the service report.
Or you take fresh steps? You are enjoying any interim order?
No, Lordship.
Okay, then we will wait. What is your name?
A Singh, Lordship.
Heard Mr. A. Singh, Learned Counsel for the applicant. What for this civil revision? This IA is there?
IA is for condonation of delay, Lordship. There is a delay of 1 day. Lordship.
1 day only.
1 day only, Lord.
On perusal of the office note, dated 11/8/2025, it appears that the service report in respect of notices issued to the, how many respondents are there?
Lordship, 6 respondents are there.
So the respondents have not been received. Stop. The registry is directed to place the track consignment report of the notices issued to the respondents by registered post with AD before this court on the next date fixed. Place this matter on 24th October. Oh, leave it. Amita. Yes,
Lordship, on the last occasion also, I suppose the appellant was absent, my lord.
what is this?
Well, this is a CRP challenging an rejection of an amendment application, my lord. But the thing is that this honorable court had granted a stay in favor of the petitioner. But that was not communicated to the trial court, my lord.
None has appeared for the applicant on call.
My lord,
This interlocutory application is for convening the,
the sole appellant expired, my lord. It was filed for substitution. my lord. This IA. 116823, my lord. But the thing is that the suit itself has been dismissed in the year 2017, my lord.
Okay.
And
none has appeared for applicant on call. Mr. What is your name?
A Rekha,
Heard Mr.
correspondent number 1.
A Deka, respondent number 1 is present. On perusal of the records, it appears that on last date also, that is on 9/5/2025, the applicant was not found when the matter was called. Considering the conduct of the applicant, this application is dismissed for default. What will happen to the main CRP?
CRP otherwise, my lord, it's not maintainable, my lord, as per my understanding, my lord. Because the CRP is an IO, my lord.
CRP also. None has appeared for petitioner on call. Mr. A Deka,
Respondent 1.
Learned Counsel for respondent number 1 is present. This CRPIO is dismissed for default.
21. Item number 31.
None has appeared for the applicant on call. Let this matter be listed in the next week on a date to be fixed by registry.
Item 42.
Lordship, as per the office note of the 8/10/2025, your lordship, respondent number 1, A, B, C, and 2, 3, 4 are complete, your lordship. And in respect of 5, your lordship, 6, 7, 8, 9, 12, 13, 14, 15, 16, and 18 are awaited.
When have you taken steps?
Lordship, we 22/9 probably, lordship. we will take
22/9/2025 this year.
3, lordship.
3.
Yes, lordship. 23, lordship. In the year, lordship. Notice was issued in the year, lordship. Lordship,
What is the evidence that you took step?
lordship.
You take fresh steps.
Lordship.
We'll call
Good.
for the postal track consignment report.
Lordship. Here is the poster, Lord, receipt. We have taken 1690.
You have the postal track consignment report.
Lordship, and
No.
that will be with the registry, Lordship.
Heard, Mr. What is your name?
T Google.
P. Gogoi, learned counsel for the applicant. Also heard Miss, what is your name?
Tika Bhargav on
R. Bhargav, appearing on behalf of for respondents, Mm. appearing on behalf of respondent number 1A, 1B, 1C, 2, 3, and 4. It appears from office note dated 8/10/2025 that neither AD card nor unserved notices have been received in respect of notices issued to respondent number 5, 6, 7, 8, 9, 12, 13, 14, 15, 16, and 18. As well as it also appears from the office note that the petitioner has not taken steps in respect of respondent number 10, 11, 17, and 19. You have not taken steps.
Lordship, probably
This
the-
is sufficient to dismiss this matter.
I may be allowed to take the first step, Lordship.
Stop. Learn it. In view of the office note, the petitioner is directed to the applicant slash appellant is directed to take fresh steps for issuance of notice on respondent number 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, and 19 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly. This is a very old pending case.
Lordship.
You take steps.
33.
Okay.
Item number 33.
None has appeared for the petitioner on call. Registry to list this matter again in the next week on a date to be fixed by it.
Item 24.
My pleasure, Lordship. Lordship, in this matter, all the respondents have appeared by filing their wakalatnama.
Heard Miss, what is your name?
Miss P. Haklari.
P. Khaklari. V. Khaklari, learned counsel for the petitioner. Also heard Miss
S. Pal, appearing on behalf of B.J. Mukherjee.
S. Paul, appearing for respondent number
3 and 6.
1, 2, 3, and 6. On perusal of the office note dated
27/5.
27/5/2025, it appears that all the respondents have been represented by their counsels by filing wakalatnama in this case.
Interim order may be continued past hour.
What interim?
Lordship,
There is no interim. Okay, interim is there. Let this matter be listed. Records have been called for.
Impugned judgment and decree dated
Let
26/9.
this matter be listed for final hearing in the second week of November on a date to be fixed by the registry. The interim order granted earlier shall continue till next week.
Deeply obliged.
Item 45.
May please, your Lordship.
My lord, in the
CRP, we have filed an IA. My lord, nothing served in the CRP. In advance said, my lord, there was an interim order. My lord, for staying the further proceeding of the title execution case. And my lord, the decree has already been executed.
Executed.
And my lord, the possession was handed over to my client. And therefore, my lord, there is nothing to stay in the execution. But what happened, my lord, after the decree was executed and the possession was handed over to us, on the next day, they had again, my lord, entered into the land and raised some structures. There is a different proceeding pending for that. So therefore, so far as this case is concerned, my lord, that there is nothing survived. And I have annexed the documents to show that the decree has been executed, it has been satisfied, and the decree has been, the execution proceeding has been closed.
So you are not pressing.
No, my lord, I am for the, my lord, I have filed an IA for vacating the interim order. I'm for the respondent. The IA is before your lordship.
I am for the petitioners, your
He
lordship.
is for the petitioner in this year.
Any,
What happened, your lordship? We have,
this IAS has been filed for
For my lord, the vacating the order of
stay.
order of stay. In fact, my lord,
But if nothing survives, your
no lordship. It is already admitted, your lordship, LCR was called for. The date may be fixed for hearing, lordship, short date.
No,
may be
but-
fixed.
but if the decree has been
No, the position of the student is still in favor of, in the hand of the petitioners, your lordship. The respondent after we got the stay by this honorable court, they have filed an application for vacating that order, your lordship. And this, against that application, I have filed my objection, your lordship. And as because lordship, the revision petition already admitted and LCR was also called for. Short date may be fixed, the
then
matter,
we
maybe
can
hard.
dispose of the CRP itself.
the matter may be
Well,
hard.
that is what I am asking for. That is what I am praying for, my lord. Your lordship, which decree has been decree has been closed, my lord. Your lordship will kindly take up my IA, and your lordship will find, my lord. If your lordship kindly comes to page 29 of the, my lord, IA. The execution proceeding is not there, my lord. There is nothing to stay. Page 29, your lordship will find
29 is an application.
of the application, my lord, in IA 336. The above case has been fixed on so and so that on the bailiff along with the Latmondal with the assistance of the police executed the decree by delivering possession of the suit.
No, no, where are you reading?
Page 29 of
IA.
my IA, my lord.
This is I, but page 29 is an,
29 lordship in the IA lordship,
yes, in I.
IA 336.
And the report, my lord, of the Nazir is also there at page 25.
Page 29 is an application,
Sorry, my lord, maybe there was something wrong. in the-
annexure D.
So prior to your lordship will find the, my lord, the report of the Nazir that it has been executed. And there is also an order of the court, my lord, that the decree, my lord, the execution proceeding has been closed.
Where is that order?
That your lordship finds at page 32, my lord, if there is no mistake in the pagination. Relevant page 33, my lord. This
Or
is
order dated 21/11.
21/11/2022.
Yes.
Case records put up on strength of the petition number such and such. Mr. So-and-so, this is a petition filed by the decree holders praying for passing necessary order in the matter containing that they have got possession of the decreed land on 16/11/2022 and the decree has been satisfied. I have perused the case record seen the report dated 16/11/2022 submitted by Civil Nazir Bailiff. From the report submitted by the bailiff, it appears that the possession of the decreed land has already been handed over to the decree holder. Keep the report tagged with the case record in view of the above. This instant execution case stands disposed of on satisfaction of.
What was the order of the stay?
Stay, my lord, your lordship will
Stay
find
was in execution.
stay of the execution.
Stay of the execution in execution case number 6/20.
Yes.
So that is no longer surviving. Yes, Mr. Petitioner.
Lordship,
Execution case is no longer surviving.
as per,
How can stay operate in a case which is no longer survives?
Lordship, my humble submission before your lordship, is because this revision petition is not challenging the execution application. Your
No,
lordship.
but stay will be vacated. This IA will be allowed.
Lordship,
So-
in that case, your lordship,
Main. What was the order?
order,
Stay.
stay order, it was
That is dated, my lord, 21/11/2022.
further proceeding of the lordship.
In the IA,
Page.
your lordship finds at page 17. ma'am.
Further proceeding of the title execution was stayed.
Now title execution no longer remains. So question of stay becomes,
Lordship, I have filed my objection in this IA, your lordship. In the IA, I have categorically stated that the paragraph 4, your lordship, of the application, it was stated that paragraph 4,
no. What is your response
yes,
to order dated 21/11/2022? Page 33 of the IA.
yeah, I have stated in my paragraph 5 that as regards the statement made in paragraph 4 of the application, it is specifically denied that the opposite party obtained the ex parte interim order dated 21/11/2022.
Those things becomes, Mr. Those
Lordship.
things have become irrelevant. How will you satisfy this court that regarding the order of the executing court, which says that this instant execution case stand disposed of on satisfaction of decree?
Lordship,
There is no challenge to that order. In view of
there
that,
is no challenge to that order.
so that order remains. And if execution case is not,
Lordship, so far my instruction, the execution proceeding is still going on there, and the present petitioners.
but your
filed
instruction
petition,
is
Lordship.
counter to what is before the court. The order is very specific.
That is going on, Lordship, so.
Which execution is going on?
This particular execution case.
It was again revived.
Yes, there is, the trial of the execution proceeding is going on, continuing.
No, which execution proceeding?
This
That-
particular 6 of 2000, which was stayed, your
Whether
lordship.
it was revived.
But it cannot be revived. What happened?
Unless the decree holder prays for revival of the,
Lordship, in that case, lordship, I'll have to file an additional affidavit.
no additional affidavit.
Bringing those, before this honorable court.
We are vacating this stay.
On the
The,
next date, your lordship, I'll submit your lordship with additional affidavit.
no next day,
Only 1 week time may be given.
no
your lordship.
time.
Lordship, because so far my instruction, your lordship, this execution.
Your instructions are counter to the materials available before the court.
We have filed lordship objection therein, in the execution proceeding itself.
But execution proceeding has been closed.
No, lordship, we filed petition there. Yes, your lordship. So lordship, 1 week time may be given.
No, we are vacating this stay. We'll fix the CRP for hearing next date. Heard Mr. M.K. Chaudhary. learned senior counsel assisted by Miss N. Dutta, learned counsel for the applicant. Also heard Mr. What is your name? T.
So, Lordship.
A. R. Som, learned counsel for the applicant. Learned
For the petitioner opposite party, Lordship.
learned
It-
counsel for the opposite party in this
Opposite
interlocutory application. Learned senior counsel for the applicant has submitted that by order dated 22/11/2022, the title execution case number 6/2014 was disposed of by the executing court on satisfaction of the decree, and therefore the stay of said case, stay of further proceeding of title execution case number 6/2014 granted by this court by order dated 21/11/2022 has become infructuous. Stop. On the other hand, learned counsel for the opposite party has submitted that the title execution case, the aforesaid title execution case is still pending. However, the learned counsel has failed to produce any material to substantiate his submissions. As on perusal of the order dated
22/11/22.
order dated 22/11/22 passed in title execution case number 6/2014, it is apparent that the said title execution case has already been disposed of on satisfaction of the decree. The stay granted by this court on 21/11/22 has become infructuous and accordingly vacated. Has become infructuous. So this interlocutory application is accordingly disposed of. In CRPK, this is ready for hearing.
NCL was called for, NCL received, NCL received. Lordship.
Heard party, same party, Councillor Nam. This case is ready for hearing. Let it be listed for hearing in the second week of November on a date to be fixed by registry.
Hello.
Oblige, your Lordship.
46.
The Lordship, with due counsel on the other side, I beg for Passover body day.
Heard Mr. What is your name?
And Bhuya.
N. Bhuya, learned counsel for the applicant, who prays for an adjournment for the day. He also submits that he has informed the learned counsel for the respondent regarding his prayer for adjournment, who has no objection to the said prayer. Stop. The prayer is hence allowed.
Your Lordship, may your Lordship fix a date for the,
No date.
okay, Lordship. Oblige, your Lordship.
May please, your Lordship. Well, there are some confusing orders regarding service of notice on the, my lord, respondent number 2.
This I is for condonation.
My lord, the I is for bring for an injunction in the, my lord, second appeal.
Okay.
So that, my lord, the property is not alienated. But then, my lord, the it might have-
Second appeal is admitted.
Yes, my lord, it has been admitted.
Now, my lord,
Notice,
so
how
far as-
many respondents are there?
My lord, if your lordship kindly goes through two orders, my lord, one in the RSA dated 5/5/2025. It will show that, my lord, the notices have been served on respondent number 1 and 3. In the RSA, my lord. 5/5/2025.
5. 5/5/2025.
My-
Applicant to take steps for issuance of notice on respondent number 1.
My lord, notices have been served on respondent number 1 and 3, and then, my lord, prior to it, we had taken steps by registered post on 28/3/2025 on all the, my lord, respondents. That your lordship will find in the note, office note. And since, my lord, these steps have been taken by registered post. And since in the IA, there is an order, my lord, where, my lord, it has been recorded that, my lord, notices have been served on respondent number 1, 2, 3, all of them. So my prayer before your lordship will be that your lordship will deem the notices to be served in the RSA also, my lord. This is a case where the, my lord, the respondents are playing with the court by not accepting. And, my lord, although there is a record that, my lord, the notices have been served in the injunction petition, they have not appeared. In the, my lord, second appeal also, although it has been recorded to have been served on 1 and 3, my lord, they have not appeared,
No, in this interlocutory application,
my lord.
whether notices have been served or not.
My lord, yes, my lord, your lordship will kindly go through the order dated 5/5/25, my lord, again, in the IA.
I number,
IA 3322 of 24.
but there is no order dated 5/5/25.
My lord, I have got them.
There is only 29/8/25, before that 4/11/24. Only 3 orders are there.
There was, my lord, another IA which we have, of course, my lord, withdrawn.
You take fresh steps. Then within 1 month,
All three opposers we have taken steps by.
but unless service is there, report is there, or at least track consignment report is there. If you have taken steps, we will call for the track consignment report from the
Your
registry.
lordship will kindly peruse the last order, my lord,
Last order, 18/9,
89, my lord.
yes.
Here, my lord, the
Notice.
notices have been deemed to be served on respondent number 1. Now, there, my lord, in fact, my lord, the appellants and the respondents are sitting, my lord, they stay in the same, my lord, campus, in the same building, part of it. And the respondent number 1 is the mother, and 2 and 3 are sons. So, my lord, 2 of them receive it, 1, my lord, does not receive it, and they do not appear. This is how, my lord, they are playing.
But if we proceed, then they will appear and ask for setting aside the order.
Let that happen, my lord, they'll come and appear, my.
No, but we have to follow the procedures. When have you taken steps?
My lord, we have taken steps thrice, my lord.
Lastly,
Lastly, on
on 6/9/25, 6,
2000.
then we can call for the track consignment report. It is available.
On an earlier occasion, my lord, the report was left. Although, my lord, he is very much there, that was the report of the, my lord.
No, but we have to, whom to believe? We'll believe the reports.
In that event, my lord, may I pray that since, my lord, 1 and 3 have been served in the, my lord, main RSA, it's only, my lord, respondent number 2. Let me serve through, my lord, Dasti through the registry.
Okay.
Only 2. Only 1 and 3 are.
1 and 3 have been served, my lord, that has been recorded already.
And in second appeal, 1 and 2 sir, 3 those.
In I Likhibu, I heard Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. S.K. Ghosh, learned counsel for the applicant. On perusal of the order dated 18/9/2025, it appears that notices were deemed to be duly served on respondent number 1. However,
One and three,
it,
my
it
lord.
also appears that notices were properly served on respondent number 3 also. However, the notices issued to respondent number 2 have not yet returned, neither any ED card has been returned. In view of above, learned senior counsel for the applicant has prayed for allowing the petition applicant to take steps for issuance of notice on respondent number 2 by Dusty mode.
Sir, I am told that, my lord, the AD card has come back, my lord, in the record. I did not check, but my learned friend checked.
But it was written only left.
Okay,
But there is another order, if I might trouble your lordship, my lord. In the IA, order dated 5/5/2025.
that is in the main case.
That is in the main.
Okay. You take steps, Dusty mode, the prayer is allowed. The petitioner shall take steps within 7 days from the date of this order for service of notice on the respondent number 2 through Dusty mode, returnable on after 4 weeks,
3 weeks.
after 3 weeks, after due service of notice on respondent number 2 through Dusty mode, the petitioner shall file an affidavit of compliance to that effect. List accordingly.
My lord, this is in the
I,
main case also, my lord, this same order. Like
in the main case, heard Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. S.K. Ghosh, learned counsel for the appellant. It appears from the office note that notice, it appears from order dated 18/9/2025 that notice issued to respondent number 1 and 3, 1 and 2, 1 and 2 have been duly served. However, the service report in respect of respondent number 3 is awaited. Stop. In view of the above, learned senior counsel for the appellant has prayed for allowing the appellant to take steps on respondent number 3 through Dusty mode. The prayer is allowed. The appellant shall take steps within 7 days from the date of this order, returnable after 3 weeks. After due service of notice on respondent number 3, the appellant shall file an affidavit of compliance to that effect. List accordingly.
your lordship has noticed, my lord, in one piece, 1 and 3, sir. 1 piece, 1 and 2, sir.
Yes.
And they don't appear.
But what is the way out?
That's why, my lord, I said, I pray, make this prayer, your lordship has been kind to allow that.
A common notice could have been issued in RSN.
If
Now, person,
Now 2 different persons are there. Let us see.
Lovely.
Yes, what is this?
And the case is a petition, PTS 11/24, which is at the Learned Additional and District Judge, number 1 of Kamloops Metro. So actually the main thing is that, the impugned order has been, has come up with 3 issues. It's in page 199 to 200.
Okay, we'll not go into issues first. First,
So I would just.
to why it is listed in orders column today.
She asked for all the issues as per order 14 CPC. And the fact is that till date, as per order 8 rule 1, they have to submit their mandatory supportive documents and the list also. So that has not been submitted, and this case was actually filed in 23, the probate case. So I had asked the honorable court to list up those, to ask the defendants there to submit the documents, and if they don't submit, make a note of it. And all the issues which they also have raised, the burden of proof is on them. For example, they've given joinder.
No,
Then-
we'll go into your questions raised by you, but only after the
Service.
appearance of the respondent side. You are appearing for
All the respondents.
all the service is complete.
Service is complete, but we have filed our collector number today only. So it has not been reflected in the cost list.
But my
Okay.
lord, they got the service way back in on the 18th and 19th at Agatha. So that
Okay.
was a big thing.
We-
And
No,
this
we will
case-
record their due, the service is complete. Now we'll pose this. Whether records would be necessary.
Not necessary.
they've
it's
already
simple
got-
This is only a draft issue. We filed a draft issue, they filed a draft issue.
No, my
Honorable
lord,
court-
just one.
No, we will not going into merit today.
All right,
Today we'll record their dues
presence.
presence and fixed a
Hearing of the trial court.
hearing regarding.
Evidence that is in order, page 199,
No.
100, order,
In this case, which order you are challenging? Which page?
page 199 to And page 200, it's given those 3 issues. And 4th is of reliefs.
What is your grievance?
My grievance, my lord, is that they have actually their petition, their, their written statement, they have raised many issues. For example, joinder, but they have not stated who they are supposed to be. Then they've raised the legitimacy issue with reference to me as a daughter and as a mother. In fact, outright, they have denied my son being my ex-husband's child.
No, but those are not taken note of by the trial court.
As per, I've already given,
Now, what do you want?
that the trial court takes up the issues. And these 3 issues will come up as per the probate guidelines by the Honorable Supreme Court. And all the issues which they have listed, which they have brought up, which I have put down in my replication petition, which the court has accepted. So those issues also be taken up, so that if there is an appeal back to this court, then the court does not have to remand back and have the issues again reworked on.
Yes, yes.
So I just want, and plus, my lord, like on this order 8 makes clear that they have to submit the mandatory documents. If they don't, it's okay. The court can't force them, but at least the court should note that they have not submitted the mandatory documents because they have got my documents. And my lord, if you can,
You are ready for hearing.
Lordship, if the honorable court decides to decide the matter today itself. And
that will be better. We
it-
can just have the trial.
Let
court
the
take
matter
up
come
the-
up on another day, so that we also, because today only we have filed our call number.
And my lord, if you can. just
Issues are framed. Tomorrow is date for.
wait for the issues, evidence from my side.
Even then it can continue.
No, we can't have, no, we must have a stay of that before we clear up this. Because my thing
In
is
the
that.
probate case, it is their petitioner's duty to prove the will. Nothing else.
No, my lord, but then a contentious probate case.
That we have to examine whether other issues are required to be framed or not.
Because this issue has to be taken up with reference to me as a daughter. Then once, suppose the probate case, the probate will does not pass the probate test, then what will happen?
It is her case. If she wants stay, I have no objections. It
No,
is her case.
it's not just my case. It has to be done as per law. And the Honorable Supreme Court in Asma, thing, I'll just one minute.
Okay, you will be filing any objection?
Page 207.
We'll have to see because it's a voluminous one. Because a lot of judgment has been also connected with this.
Okay.
Page 207 to 223, that is the order and judgment of the Honorable Supreme Court in Asma Latif versus Shabi Ahmed.
Heard,
Yeah.
Miss, not Mrs. Heard Miss Sanchita Roy Chaudhary, petitioner appearing in person before this court. Also heard Mr.
BK Bhagavati.
B.K. Bhagavati, appearing for all the respondents, who submits that he is yet to, you have filed Vakalatnama?
Today.
He has filed the Vakalatnama only today and needs some time to go through of the petitioner before he makes submissions in this court. It is submitted by both the sides that requisition of trial court records may not be necessary for deciding the issue before this court in this civil revision petition. And therefore, at this stage, no record is requisition.
Their written statements and my probate petition and my
Are there.
requisition, it's already here.
There. Okay.
And there are two orders, that is of 31st and 16, because on the 16th order, that is page 197, the court has already accepted my replication petition of 972 by 24, where I have put in I've answered to every issue raised by them. So the draft issues are already those which I had submitted.
Petitioner appearing in person. The contention of the petitioner appearing in person is that the trial court has framed only 4 issues, whereas considering the pleadings of both the parties, some more issues ought to have been framed to finally settle the dispute between the parties. This contention is required to be examined by this court, and therefore choose a date. Tomorrow we'll keep,
Tomorrow we have to file, I'll have to file the petition.
I will put a halt on that tomorrow.
File a petition there, we have no.
We need to file the petition out there to halt that thing as per your order, your lordship. So can we have it within a few days' time? So we can settle this issue fast.
So this,
Early
Let
next
the
week.
matter, next week is already holiday.
No, next week, we can have earlier because we don't need any other records. Just my petition out here has all the necessary documents. We can have it on Friday also.
no, not Friday. Let this matter be listed on 4th of November. 4th of November. Learned counsel for the petitioner, the petitioner appearing in person has submitted that the next date of probate title suit number 11/2024 is fixed tomorrow for evidence of the plaintiff side. And unless the issues raised by her in this revision petition is decided before initiation of examination of evidence, she may be prejudiced. And therefore, the trial court is directed not to proceed with the examination of plaintiff's witnesses tomorrow, that is 14/10/2025, and wait for further instructions from this court. List accordingly on 4th of November.
Item 48.
May I please, your lordship? Lordship, I was referred by the appellant husband to pay the balance amount of 3 lakhs out of 8 lakhs, my lord. My lord, on 8/9/2025, balance amount of 3 lakhs was paid. My lord, as per the office note dated 7/10/2025,
Why this IA has been filed? For balance amount. It has been paid to you.
it
You,
was paid to the appellant, my lord,
your husband.
husband.
What has happened to the main case, matrimonial appeal?
My lord, dispose of this case.
Where is the evidence which would indicate that you have paid the balance amount? When have you paid?
Judgment dated 25/11/2024, my lord.
No, your submission is that you were directed to pay balance amount to your wife,
Yes, my lord.
that you have paid.
Paid.
When?
8/9/2025, my lord. Sir, office note dated 7/10/2025, you check, my lord.
How much was the balance amount?
3 lakhs, my lord.
Okay, then we'll dispose of this. I heard Miss L. Barua, learned counsel for the applicant. Who is the applicant?
Husband, my lord.
Applicant. None has appeared for the respondent. Learned counsel for the applicant has submitted that in pursuant to the directions of this court, the applicant has paid the balance amount of rupees 3 lakhs, has deposited the balance amount of rupees 3 lakhs to the registry on 7/10/2025. Stop. On perusal of the office note dated 7/10/2025, it appears that the balance, the amount of rupees 3 lakhs have been deposited by the applicant before the registry. In view of this said fact, this interlocutory application has become infructuous and accordingly disposed of.
May I please, your lordship, I have filed a written objection against the IA today itself, lordship.
We have received the copy today, your lordship. Before bring.
What for IA is there?
It's for injunction in the appeal, your lordship.
Last order, your lordship, the status quo order was passed, your lordship. Even because of the status quo order, they have violated the order and they have constructed the building, your lordship.
You are seeking injunction
Yes,
from further construction of
yes.
the.
They will-
Now, what is your submission?
Lordship, we have received the copy today, lordship. We need some time to go through the copy, your lordship, and
Heard Mrs. Nazneen, learned counsel for the applicant. Also heard Mr. A.R. Shom, learned counsel for respondent, who has submitted that the respondent have filed written objection against the interlocutory application filed by the applicant today only. It is submitted at bar that some time may be required to go through the said objections. Hence, a date may be given for hearing on this interlocutory application.
and your lordship, the interim order may continue, lordship.
Earlier interim order may
The
continue.
prayer is allowed. When?
On 19/9, the status quo was passed, your lordship.
When we will,
No, November last week, lordship.
November last week, the prayer is allowed. let this matter be listed on a date in the last week of November on a date to be fixed by registry. The interim order granted earlier shall continue till next day.
Oblige, your lordship.
Is it 45?
May please, your lordship. Lordship, before going to the IA lordship, I would like to take your lordship to the main appeal for a moment, lordship. In the main appeal, I was been added as a respondent number 3. And lordship may.
Who are you?
I am the mother of the deceased person.
Okay, you are the claimant.
No, I am the pro forma opposite party.
Okay,
And for a moment, lordship, only the operative portion was at page 31, lordship. At page 30, lordship, the award of the compensation has been granted at paragraph 52. Have lordship got it? Page 30, the memo appeal.
30 of
Memo of appeal, lordship.
it has been not numbered, no pagination is
Okay, lordship, I am the respondent. The internal page 22 of the judgment, lordship. Down below, right side,
Yes, yes.
paragraph 52, lordship, and award of rupees 26 lakhs 4,312 has been granted. And the very next page, lordship, page so paragraph 58 and 59 may be read, lordship. May I read it?
Yes, 50?
58, paragraph number 58, lordship.
Yes,
Internal page 24. Out of the awarded amount, rupees so and so shall be released to the claimant, Runumani Das, wife of the deceased, to meet the immediate expenses. Paragraph 59, the claimant amount shall keep an amount of rupees 5 lakhs in fixed deposit accounts in her name in a nationalized bank in her locality for a period of 5 years. Paragraph 60, lords. An amount of rupees 10 lakhs plus rupees 53,112 medical expenses so and so shall be released to pro forma respondent number 2, that is the mother of the deceased. Now
that is you.
yes, that is me. Being agreed by this order, lordship, the insurance has preferred the appeal. While preferring the appeal, there was a delay. Now, lordship, I will trouble to lordship to take up the IA filed by me, IA number 3033.
3033. This is an application for condoning the delay.
No, lordship. Now, I will take your lordship to
Oh.
page 13.
This IA has been filed by you.
Filed by me, lordship. Lordship, kindly peruse page 13 of the IA number 3033.
Yes,
Page 14 onwards, lordship, the order. By this order, lordship, the heard so and so land control applicant, so and so for opposite party number 1, and lordship, essential for opposite party number 3, where when I have been added as the mother. And lordship, the delay has been condoned. The delay of 28 days, that was condoned. Lordship will find the next page. That's page 15. Subsequently, lordship, the appeal got listed. I have annexed the cause this, lordship, on 27th of August, and page 16, lordship, as item number 45. Lordship will find that in page 21. Have lordship got it?
yes.
Yes, very surprisingly, lordship, the councils appearing for the
Item number 45.
yes, item 45, lordship. There, lordship may kindly peruse. The councils appearing for the opposite party number 1 and 7, their names has been shown. But the council appearing for opposite one number 3, this name was not shown, for which I could not appear. And subsequently, lordship, the very next page at page 23, annexure C. Then lordship, appeal was admitted, lordship, and in the stay petition, an order was passed by this honorable court. Lordship will find the operative part order starts from page 24 onwards.
Yes.
Yes, may I read it, lordship? heard
Yes.
so and so for the applicant, also heard so and so for respondent of appeal number 1 and so and so for respondent number 5. Application for so and so, application under order 41 rule 5 of the CPC, praying for stay of the operation of the impugned judgment and award dated so and so passed by another MSCT 3 in MSC case number so and so. Since the connected appeal has already ended, the operation of the judgment and award dated so and so shall remain stay, subject to the condition of the applicant. Appellant shall deposit 50% of the total award amount before the registry. On such a deposition being made by the learned applicant, the same may be allowed to be withdrawn by the claimant opposite party on proper verification process. I am against only this portion, Lordship, because since I am also one of the person who is entitled for the award of compensation, Lordship, the 50% which is deposited before its registry, I am also
You also
entitled to get-
entitled to share.
Yes,
Okay.
I also need the share, but since my name has not been shown, I could not appear, and
But whether the amount has already been
to my knowledge, Lordship,
disbursed,
to my knowledge, no, because after coming to the knowledge, after receiving the copy, Lordship, I have
you are not staying with your daughter-in-law,
my daughter-in-law left the house after my son
died.
died,
Okay.
and she even did not stay during the ritual period also. But that was not, I could not prove before the learned trial court, so I am not pressing on that. And also after getting the service copy, after passing of this order, I have preferred an application before the registry of this honorable court, bringing to the knowledge that I have already preferred an IA for modification of the order dated 27/8/2025 on 5/9. So I think the award is, the amount is not disbursed with that. My learned friend will be appropriate person, you can, and
You are insurance company,
No, my lord. I am for the
daughter.
daughter-in-law.
Yes. You have anything to say?
My lord, I have nothing to say as because as per order of the award,
Proportionate, how much
Yes,
amount
proportionate.
was granted to you?
so out of 26, 15 lakhs was granted to him, and 10 lakhs 50.
So your share is lesser.
A bit less.
What is the, now out of 50%, how much you will get?
In terms of percentage, Lordship, it will be difficult
No,
because.
what order this court will pass? Some order has to be passed.
Yes, that is true.
So
Lordship.
what is your submission?
If he agrees, Lordship, then equal share at present, then later on it can be calculated if my learned friend agrees, Lordship. Because the
Yes,
amount
it
is,
should be proportional, my lord, not equal.
it should, you work out the proportion.
Proportion,
It is easy to work out,
yes, Lordship,
but
250.
don't burden it on the
250
court.
you will get,
no, not.
And
not-
I will get
Not 250
350.
exactly, Lordship. Let me calculate, Lordship.
You work out the proportion, we will heard Mr. S.N. Krishnatreya, learned counsel for the applicant. This is in 3033. Also heard Mr. S. Alim, learned counsel for this opposite party number
1.
number 1. This interlocutory application has been filed by the applicant.
May I interrupt, Lordship? It is 60/40, Lordship.
You will get 40.
More 40 point something and 59 point something, later
Mhm.
60/40, it will be convenient. Or
Also-
59 point something percent is
Can-
difficult.
Applicant, namely Srimati Niru Das, who has been arrayed as respondent number 3 in the connected MSC appeal number 366/2025 filed by the insurance company appellant. The counsel for the applicant has submitted that by order dated 27/8/2025, a coordinate bench of this court, while admitting the appeal, had directed, while admitting in the appeal and suspending the operation of judgment and award dated 9/9/2024, had directed the insurance company to deposit 50% of the total awarded amount before the registry within 4 weeks from the date of the said order. So it was further directed that on deposit of the directed amount, the same shall be allowed to be withdrawn by respondent number 1 after proper verification and identification by their advocates. Learned counsel for the applicant has submitted that the applicant is aggrieved by the observations made by the court on 27/8/2025 to the extent that it only allowed respondent number 1 to withdraw the entire amount, whereas the impugned judgment had proportionately distributed the award between the applicant and respondent number 1 in the proportion of 40:60%. And therefore, he submits that the present applicant is also entitled to withdraw 40% of the deposited amount by the insurance company.
It will come to actually 42%
42%
and 58%.
42 is to 58 করে দেব 42% of the deposited amount. He further submits that on 27/8/2025, when the interlocutory application filed by the insurance company was called on for hearing, the learned counsel for the present respondent could not appear before the court, as in the cause list which was published on that day, the name of the counsel for the present applicant was not reflected in the cause list, and therefore the counsel missed the case. Stop. On the other hand, learned counsel for respondent number 1, Mr. S. Salim, has fairly submitted that since the award has been proportionately, since in the award itself, the Motor Accident Claims Tribunal had proportionately distributed the amount between the applicant and the respondent number 1 at the rate of 40%, 42% is to 58%, he has no objection if 42% of the deposited amount is disbursed to the applicant after proper verification. Stop. In view of the submissions made by learned counsel for the parties, this interlocutory application is disposed of with a direction that the order dated 27/8/2025 passed in IA number 2687/2025 is modified to the extent that on deposit of the 50% of the awarded amount by the insurance company before the registry, same shall be disbursed to the present petitioner, that is respondent number 3. Is respondent number 3 or 2?
In the appeal, Lordship, I am arrayed as three.
Respondent number 3 and respondent number,
Nirudas.
namely Niru Das, and respondent number 1, namely
Runumoni Das.
Runmoni Das,
Runumoni.
Runumoni Das, at in the ratio of 42% is to 58% after proper verification by the registry. This interlocutory application is accordingly disposed of.
The main appeal, registry will be directed to reflect my name, Lordship, while listing the.
In the main appeal, none has appeared for the appellant on call. Mr. S. Krishna Tre. S, only S.
S.N. Krishna.
S.N. Krishna Tre. Learned counsel for respondent number 3 is present. Mr. S. Alim, learned counsel for respondent number 2 is also present.
Respondent one.
One is also present. The registry is directed to reflect the name of Mr. S. N. Krishna Tre as engaged counsel for respondent number 3 in the cause list in this case henceforth. It appears from office note dated 8/10/2025 that the appellant has not yet taken any steps for issuance of notice on respondent number 5 and 6. And the trial court record, I say, and the trial court record have also not been recorded. And the records of, not trial court, and the records of concerned MAC case have not been received yet from the concerned motor accident claims tribunal. Issue reminder for the same. The appellant shall take steps for issuance of notice upon respondent number 5 and 6 within 7 days from the date of this order by registered post with AD as well as by usual mode, returnable after 4 weeks, list accordingly.